Yes.
My lord. It was before my lords on 12/3. Since my file was misplaced, I made mention and my lords have been pleased. Now, my lord, here the case is a, a police constable has earned 10 black marks. And owing to 10 black marks, his service, he was removed. And the honorable court has held that in one of the proceedings, the three black marks which were awarded lost its force. Therefore, they had to be excluded. So the order of dismissal removal was set aside. Now, before I take my lords to the order, may I take my lords to the Orissa police manual? My lord may kindly. May I show my lords 824 first? 824 of the Orissa police manual. 824.
Olga,
My lord?
your book is not this edition.
Yes, ma'am.
This edition.
Ma'am. Page 445.
425.
445. 445.
Yes.
May I please rule 824, madam?
Yes.
My lord, I am placing 824. Description of departmental punishments. My lords will see the following punishments may be inflicted departmentally on a police officer below the rank of deputy superintendent: dismissal, removal, compulsory retirement, reduction in rank, reduction in time scale, withholding of next increment for a specific offence, with or without corresponding postponement of subsequent increments, black mark or marks, removal from any office, censure, warning. My lords, these are the punishments available, my lord. Then may I take my lords to 835. 834, my lord, I'm sorry.
Yes.
My lord, 834, imposition of black marks. Black marks may be awarded alone or in addition to other punishments enumerated in Rule 824, except dismissal or removal, to all officers of and below the rank of inspector. No more than one black mark shall be awarded or any one offence. That will be my lord for any one offence except when moral turpitude can reasonably be inferred. 3 black marks shall ordinarily entail reduction or forfeiture or withholding of an increment, the period of which shall be specified in the order. And after the period is over, the officer will be restored to his former position. Such reduction or forfeiture or withholding of increment shall not carry any black mark value. C. It shall be left to the discretion of the officer awarding the third black mark to waive the penalty noted in clause B. In exercising this option, he shall consider the officers for which the previous black marks were awarded, the length of time that has elapsed since they were awarded, any good service the defaulter may have to his credit. Then, my lord, 835. Effect of black marks. A reduction or forfeiture or withholding of increment for specific offence shall carry the following black mark value. A reduction up to 6 months, 1. Up to 12 months, 2. Longer than 12 months, 3. Then, my lord, the last and the most important one, 836. Effect of 9 black marks. 9 black marks shall entail reduction in rank or compulsory retirement or removal or dismissal whenever any member of the police below the rank of deputy superintendent police has been awarded 9 black marks. Proceedings shall be drawn up against him with a view to awarding any of the above punishments. Now, my lord, this is the position of as far as black marks are concerned, my lord. Now, my lord, may kindly see 837.
Just a minute. Yes.
My lord, 837, I am reading. General rules as to black marks. Black marks shall remain permanently on record and be taken into consideration in deciding the nature and extent of subsequent punishments, provided that the due allowances shall be made for good service marks and any other recognition of good work on record of the delinquents, on record in the delinquent's favor. Now, my lord, I will take my lords to the factual question. The petition. Please. Now, the petitioner was, after earning 7 black marks, my lord, he was cautioned that here you have already earned 7 black marks. This was brought to his notice. Now, thereafter, he again misconducted as per our record, my lord. So, he was given 3 black marks, so totaling it up to 10 black marks.
So after 7-3.
My lord.
After 7-3.
My lord. After 7, 3 black marks were again made, so 10 black marks. Now, so a proceeding was drawn up since 10 black marks more than 9, and he was removed from service. That order was challenged in appeal, confirmed. He also carried a revision petition before the DG, that was also rejected. Carried a mercy petition before the state government, that was rejected. and now he was before my loss. Now, may I take my lord to page 46 of the impugned judgment, my lord. Page 46, my lord. Internal page 4 of the judgment.
Yes.
I will read 3-4 relevant paragraphs, my lord. Paragraph 4.3. It is contended, my lord, sir, it is contended that challenging such order of removal, the petitioner though preferred an appeal before the appellate authority under Annex 7, but the appellate authority by the order under Annex 8 while rejecting the appeal confirmed the order of punishment so passed on the petitioner. The revision filed by the petitioner against such order of punishment was also rejected by the order under Annex 10, even though mercy petition was filed by the petitioner before government opposite part number 1 to reconsider the order of punishment, but the same was also rejected by the government under Annex 1130. Learning counsel for the petitioner, my lord, next paragraph 4.4.
No, but I have one question
My lord.
to whether this OCS CCA rules
My lord.
shall apply in his case or not.
No, my lord.
Why?
Because he is governed under police manual, my lord.
Why? Why? Please see OCS CCA rules.
This police manual, are the rules framed or executive instructions jotted down?
My lord, it provides the asterisk
No,
mark.
please.
My lord.
Whether this police manual rules which you are saying, is it under Article 309 or executive instructions jotted down through the years? Or is it
Yes, my lord.
through the years and that has become practice and that has been followed
And some,
conventionally
my lord, and some of the rules
for the
have-
purpose of police department?
my lord, and some of the rules.
But OCS CCS rules, as my lord posed query, whether is this not applicable to government servants, to the police department also? I think this is the.
This is the question. In fact, there you are right. And that judgment of Supreme Court came from Odisha.
My lord.
That the police manual is not entirely, the entire police manual does not have this statutory
Yes.
force.
Yes,
Part of the provisions which have been made
yes.
in exercise of some statutory power, they have statutory force. Otherwise, the police manual is just executive instruction. That's no statutory force. One. Two. Now, please see section rule 3 of OCS CCA rules. So, why these rules shall not apply? And this police manual was framed when?
Well, this CCA rules, man.
Yes, no. The police manual was.
Police manual was, my lord. Police, it's under Police Act 1861.
Police manual is not under Police Act 1861. These are based on.
Executive instructions jotted down. And,
Yes.
these are all convenience sake, they have put it in
Right, ma'am. But to answer my lord's query, when actually, I don't have that answer.
All right. You may not have the answer. Please come to rule 3.
Ma'am. This rule is 1962 rules.
Right.
These rules apply to all government servants except persons in casual employment, persons subject to discharge from service on less than 1 month's notice, persons for whose appointment and other matters covered by these rules, special provision is made by or under any law for the time being in force in regard to matters covered by such law and members of all India services. Notwithstanding anything contained in sub-rule 1, these rules shall apply to every government servant temporarily transferred to a service or post coming within exception C in sub-rule 1 to whom, but for such transfer, these rules should apply. Notwithstanding anything contained in sub-rule 1, the governor may by order exclude from the operation of all or any of these rules in case of any government servant or class of government servants, if any doubt are.
That will not apply. Your police manual will have no application in view of specific provision under the rules. One. Now, do you have volume 3 of the police manual?
Volume 3, man.
Yes. This must be volume 1.
Volume 2.
Volume 3 contains the procedure prescribed for
Appendix.
disciplinary action.
Yes.
All right.
Appendix.
It lays down the detailed procedure.
My lord.
But even that has lost its relevance after 1962 rules. These rules will have application.
My lords, I can, subject to my lord's acceptance, I can satisfy my lords that this CCA rule will not apply. My lord may give me one opportunity, I will satisfy.
This is a very important question
My lord.
because once we hold
Ma'am.
that the CCA rules will only apply, then you cannot take any action in accordance with the provisions of the
Ma'am.
police manual.
Even this judgment will also have no application.
Yes.
Yes.
Yes. Whether this question has arisen, never. Whether this question has been dealt with.
Yes, my lord, if I remember also, I was talking, I think once this.
Once this was arisen, in the case of that inspector case, whether that PMR they will govern under, whether they will be governed under PMR or CCA rule, that what is that they are governed under CCA rules.
Then why black mark and anything?
Yes, my
No.
lordship, yes.
From your mouth, it fell that CCA rules will apply
No, yes, no, CCA rule in respect of inspector and above.
and above.
Yes, because that
Oh,
824,
because
because
police
824 is
manual,
applicable in respect of inspector.
can police manual rule
It can-
curtail the
Yes.
effectiveness of CCS rules?
My lord has raised a pertinent question that
You are putting the horse before the car, not before the cart. But
that is the law, my lord, because I know that in view of that the provision under
This is
section
law. These rules have been framed under Article 3.
309 and these are simple executive instructions, PMRs, unless those provisions are made under a Police Act. Those who are made under Police Act, they have statutory force.
So we will have to read Article 311 with these rules and then we will test whether his removal
Yes.
is correct or not.
Actually, my lord, I was not expecting this question, so.
Not expecting. Why?
My lord,
I'll
the applicability of the rule, so my lord, this is a point of law where my lord may grant me opportunity and
It
I'll.
is a very important question.
Yes, yes. And I will also come with that judgment. But
This is important. These rules. Violation of the executive instructions issued from time to time.
yes, but and your lordship is submitting that volume 2, volume 3, that is not volume 3, that is volume 2, appendix 49. The-
Yes, Appendix 49.
Yes, that same procedure has been prescribed in the CCA rule. But if Lordship says that in view of Rule 3, that has become redundant.
Now you examine that,
Yes,
which you are just telling some time ago, this court,
Yes, the
before
time,
this court,
I'll come with that judgment.
Huh.
If that has been
so
decided
if
on that
this
issue,
court
but
has already held,
yes, ma'am. I'll come with that.
perhaps you have
We'll
to
see.
give a second thought.
We'll have to see. That. 1 week.
Yeah, Lordship,
Please examine.
has to
I am
think
part of the respondent, my lord.
Yes.
My lord, the major penalty has been imposed.
Please examine this question, whether in your case, the police manual will apply or Odisha Service Classification Control and Appeal Rules are applied. That is a legal question which,
Have you raised that plea before the writ court?
Pardon, please?
Have you raised this plea before the writ court?
No, my lord,
No.
this nowhere.
He agitates on facts.
Yeah.
Now, whether it is 10 or 3 are forfeited or
Yeah.
that is after punishment being suffered.
My lord's question.
Huh.
we will consider both the aspects.
Yes, ma'am.
We will see what can be done.
On the last occasion, we have made some observation
Right.
while sitting with Justice Sarangi. We have recorded his submission
My lord.
on 11/1/2024.
In fact, three black marks
Yeah.
disappeared after imposition of increment, in fact, stoppage of increment.
That is the judgment of this honorable court, and
Yeah.
I am trying to.
So
That 3 goes, then
Yes, ma'am.
this
Disappear.
becomes 7.
Man,
So 7 doesn't entail him to get dismissed.
true. I am trying to. I will be trying to persuade my lords that 3 doesn't go. Those 3 remain.
All right. Well, doesn't go because of rule 837 or something.
837.
We will see. But that is the larger question,
My lord.
because the CCA rules do not carve out any exception.
Yes.
All government servants.
Yes.
Should I record our question?
And also you cannot say that this is in addition to that.
No, no,
You are not also
No, that
stated anywhere.
That which are.
Police manual is in addition to or not in derogation to rules. There is no provision like.
in view of Rule 3.
My lords, may kindly give me time till April 1st.
Should I record the question or just leave it? Leave it, huh? Whatever. Should we record our question
As my lord, please.
during the course of hearing of present intra-court appeal? Scorecard. The respondent was a constable,
My lord.
in Odisha Police. Exercising, invoking provisions under the police manual with particular reference to rules 824, 834, 835 and 836. The respondent has 834, punishment of dismissal from service came to be imposed upon the respondent. So stop. The order of punishment has been set aside by a learned single judge of this court by an order dated 15/5/2023, passed in WPC number 800 of 2016. Full stop. Next. During the course of 2016, the said order of the learned single judge is under challenge in the present appeal preferred by the state of Odisha. Full stop. Next. during the course of hearing of this appeal, a question has arisen as to whether for taking any disciplinary action against the it is not in dispute that the respondent is a government servant. As defined under section 2 bracketed F of Odisha Civil Service Classification Control Appeal Rules 1962. Full stop. During the course, in that background, comma, during the course of argument, during the course of hearing of this appeal, a question has arisen as to whether OCS CCA Rules 1962 shall govern disciplinary action against the officers, against the police personnel oblique officers of the state, or action or the Odisha Police Manual. So stop. The nature of the provisions under the police manual, that is as to whether they are statutory or not, is also a question which has emerged during the course of hearing. So stop. Next, learned counsel, learned AGA representing the state of Odisha seeks adjournment to examine the legal position. So stop. List this matter on 2 weeks as the
My lord, may
First
kindly
case.
accommodate me till first week of April.
first week of April. First week of April. All right. Second,
My lord, obliged.
second, third of April. Third of April. To be listed within first 5 cases.
Item number 2. Please, Your Lordship.
Yes, sir.
Here, Your Lordship, the present writ petition in the nature of public interest litigation. Sir, the present petitioner, including other persons, are the land outstay. Land outstay. They are displaced person. They are land acquired by Upper Collab Irrigation Project, Your Lordship. Subsequently, where they were resettled, there they have allotted some land, Your Lordship, but subsequently they are using unused land as agricultural purpose, Your Lordship. In that respect, they have approached collector to settle that land in their favor, Your Lordship. That is annexure 1 and 2.
How many persons?
That 135 families, Your Lordship.
So you are a resident of that village.
Yes, Your Lordship. That is column number 7.
So you are the leader.
My lord,
You are the leader of that village.
that is
Who asked you to approach?
my lord.
Who asked you? Who suggested? Who advised you? Who authorized you
Your
to
Lordship,
take up their cause?
here, Your Lordship, for myself and for others, I have,
Huh?
that is in the nature of public interest litigation, Your Lordship.
Petitioner himself is aggrieved.
Yes.
He is an aggrieved person, not as a public spirited person, he has not filed this case. He is aggrieved, and along with him, he is claiming that some other persons are aggrieved.
But none has, none is there on record.
My lord,
Yes.
None is there on record.
No.
except him,
His soul has come.
yes.
Even affidavit is also silent. about it.
Yes. But in the representation, Your Lordship, they are putting signature all the villager, Your Lordship.
And when was the foundation stone laid?
My lord,
When was the foundation stone laid?
that is 1975, Your Lordship.
To come after 50 years.
My,
File your writ petition after 50 years. All right.
my,
A very
What,
old
sir?
project. Upper Kola project is one of the oldest project of Korapur.
but after their resettlement, they are using for agriculture purpose that land, Your Lordship.
That is of 1975, Mr. Counsel. You have filed
Yes,
the
yes,
application
yes, yes.
almost 50 years after that. So what do you want?
Your Lordship, in the meantime, the representation already forwarded to the special land acquisition officer, Your Lordship, that is annexure for Your Lordship.
The
Maybe take decision, Your Lordship.
sorry. The petitioner is a villager of which village?
Upper, what is the village name? Name of the village?
Column number 7, Your Lordship. Till that they have not getting
Colony
revenue
number
village
7.
status, Your Lordship.
Colony number 7 of Upper Kola.
Dam project.
Colony number 7
Upper Kola Dam project.
of Upper Kolab Irrigation Project in the district of Korapur. And have been Korapur. Full stop. He has filed the present writ application in the nature of public interest litigation, seeking direction to the collector Koraput to consider the case of their So what issue did you raise in your representation? So you were already rehabilitated.
My Lord.
You were shifted to colony.
Rehabilitated in column number 7, Your Lordship.
Then what more do you want?
Subsequently, they are using some unused land for their agriculture purpose, Your Lordship. Are prayer to settle that land in their favor, Your Lordship.
Actually, they are using some government land, perhaps forcibly and illegally. Now the district administrator might have taken steps for eviction. So they have filed that this land should be settled in our favor. As a land ousting of 1975.
He can again come to the for contempt. I want to avoid that.
Let's see the prayer. In the prayer, he has noted
The petitioner
at page 10.
claims to be a resident of an area which was acquired for Upper Kolab irrigation project in 1975. So stop. It is evident from the averments in the present writ application file in the nature of public interest litigation that the persons who stood displaced because of the said project were rehabilitated in colony number 7. So stop. The petitioner has approached this court claiming to be representing other similarly displaced persons seeking a direction that the that during the course of time, families of the said displaced persons has grown up and the land given to them for their rehabilitation was insufficient or inadequate. So stop. Next. London Council representing the state of Orissa has submitted that petitioner himself claims to be a displaced person and he cannot claim to be espousing the cause of others for their rehabilitation. So stop. This application in the nature of public interest litigation is not maintainable. So stop. Next. After having gone through the pleadings in the writ application, comma, in our considered opinion, comma, it lacks bona fide for the reason that apparently consequent upon displacement in 1975, they were the petitioner and other similarly situated persons were rehabilitated. So stop. On the ground that in course of time, the families of the displaced persons have grown up in number, comma, the petitioner cannot maintain this public interest litigation. So stop. This application is devoid of merit and is accordingly dismissed.
May I pray one thing, your lordship?
Unnecessary.
Item number 3.
Worships, item 3, I'm appearing for the appellant.
My lord, if anybody associate of my lord friend is here, I can give a copy.
Which item? 3.
The order has been passed, my lord. Please move out.
Yes.
Copy में भी साधा नहीं.
So
I'm
we
giving
should
one
dispose
Xerox
it
copy,
of.
I'll give.
You can take one.
I'll give, madam. Within 10 minutes, you will be received.
They have rejected our claim. They have rejected.
So what for the matter has come?
Lordships, this was a case where the writ appeal was filed because they were the honorable the learned single judge had in fact directed that they should look into our representation within a period of 4 weeks.
So
which
now
now they have rejected. That's what I heard. The
you can
learned-
challenge.
I will challenge that, Lordships.
Learned AGA representing the state of Odisha has produced before us a copy of an order dated 14/3/2024 passed by the Health and Family Welfare Department, Government of Odisha, whereby the appellant's representation has been rejected. So stop. Learned counsel, Ms.
Rajdeepa Behura.
Rajdeepa Behura, appearing on behalf of the appellant in the said background, seeks permission to withdraw this appeal with a liberty to question the legality of the said order dated 4/3/2024 before appropriate forum in accordance with law. That will do.
That will be, my lord, 14/3.
14/3, Lordships.
Okay.
14/3/2024 in compliance of the order dated 21/2/25 passed in WPC number 2013 of 2024. Is it clear?
That will be, my lord, 14/3. My lord,
14/3.
again, my lord said 4/3. So that's
14/3.
Yeah.
Obliged, Lordships.
Item number 4, my plea the order has been complied with.
Lordships, but your lordship said director personal appearance. In fact, long before the date was fixed, he had complied with the order, my lord.
So therefore,
No, I said, he has complied, my lord. Lordship had discharged him because he is present before lordship.
is present. In the light of this court's order dated, which is the order? Who is present?
16/2/2023.
Tahsildar Odogan.
Order, my lord.
Which is the order? Which is the order? By which order he was directed to be present?
1/3/23.
But he was directed to comply the order dated 16/2/2023. And because that was not complied with, he had filed the contempt. And contempt was disposed of on 26/9/2023.
All right. Order dated 1/3/2024. The Tahsildar Odagaon is personally present in court. Is not in dispute that this court's order dated, which order dated 16/2/2023 passed in WPC number 2752 of 2023 has been complied with. Stop. in such view of the matter, the present contempt proceeding stands stopped.
For orders item number 5.
My lord, I am in VC, my lord. My lord, I am in VC, my lord. My lord, I am challenging the Honorable High Court Single Judge Court order, which has passed in 4th September 2023 as a forest case, my lord. In this case, I have so many good grounds because I am a literate driver and purchasing a truck as a loan basis.
Now,
And
where is the
I-
order?
Yes,
Where
my
is the
lord.
order?
Order annexor 1, my lord.
Page
Annexor 1.
23, page 23.
Just a minute.
Page 22, my lord. Annexor 1, my lord. Single judge court order, my lord. Justice K.R. Mahapati, my lord.
Yes.
My lord, in this case, I have filed one good grounds, that is the annexor 6, which has been written in Oriya, but in the paragraph, in the read petition, my lord, I have mentioned, in the read petition, I have mentioned that in paragraph, my lord, my lord, 4, that the truck, in paragraph, my lord, 5, my lord, on 2nd February to 1992, at about 5:30 am, 395 candulips already loaded in the truck, and three persons were, one as Pradeep,
Mr.
Babula.
Counsel, your vehicle was being used. This is an admitted.
Yes, ma'am.
Then
Yes, ma'am.
confiscation is valid.
I am admitted that my vehicle is used. My lord, I am under matric. My qualification is under matric. My lord, I am only a driver and purchasing a truck that the loan basis to manage my family, my lord. My lord, this is a case that I did not know about the forest offense, forest permit, any other things.
All right.
I have in this truck, my lord, there is the Kendulift owner, Pradeep Babula, and Pitamar Pradhan was with me, and they have already passed 3 and 4 check gates, my lord. After that, Athagad police has obstruct me and show me the said show me the paper of transporting of Kendulips. But I directed that the police person, that the Kendulip owner is this such and such person.
We do not find any merit, Mr. Counsel. Everything is admitted.
No, my lord, merit, my lord, annexed 6. My lord, I have annexed and annexed 6. That the in the range of, sir, before the range of, sir, one Kendulip owner, Pitambar Pradhan, already stated in this case, my lord, that annexed 6 are already in Oriya, my lord. Ame au dui jana sanga Pradeep Sahu Babula, man, page 40, my lord, page 40, my lord, annexed 6. My lord, page 40, my lord.
Yes, we have.
Yes, my lord. ଆମେ ପ୍ରଦୀପ ସାହୁ ଏନେ ବାବୁଲା ସାଙ୍ଗ ଧରି କିଶୋର ନଗର 3 ଜଣକ ମିଶି ଆମ ଗ୍ରାମ ଟାପୁରୁ ସିଙ୍ଗାରୁ 395 ମଣ୍ଡଳ କେନ୍ଦୁପତ୍ର କିଣି ଟ୍ରକ୍ ନମ୍ବର 167 ଆଜ୍ଞା ମାଇ ଲର୍ଡ, ମାନେ he is admitted, my lord, but the authorized officer admitted in the range officer, He was on the Pitambar Pradhan already in bail. I am also bail. My truck has been, my lord, seized. And my truck has been released by the Honorable High Court, Justice Chatterjee, my lord. There is a council, my lord and senior, late Jatindra Mohan Mahadev. My lord, I am praying before that the Lord and single Judge High Court, my lord. That is my good grounds. That is why the SCF authorized officer did not take action against the Kendupatra owner, Kendu lift owner, against only me, my lord. That is my point of view. That they have been stated in the range of
provision, confiscation. Under the Forest Act.
Orissa Forest Act.
Yes, you, in the meanwhile, you may continue.
Yes, my lord, I have filed to IA one continuation of delay, my lord, 54 days, my lord. Kindly, my lord, continuation delay, 54 days only, my lord.
What is the delay?
A delay, my lord, that is the 92 years old age, my lord, senior citizen. 92 years old. That
What is the delay?
Delay is, my lord, the petitioner did not know about the law and did not know that the
Sir, how much delay?
54 days, my lord, only 54 days, 54, my lord.
So we will condone your delay.
Yes, my lord. Another, my lord, another 8007 already I filed, my lord, for the stay of the confiscation proceeding, my lord, by the authorized officer.
Confiscation order has already been passed, no?
Confiscation order passed by the London single judge. I have filed an IA for stay, my lord. Kindly, man.
Stay to stay the impugned order of the honorable. That is the prayer.
Yes, yes, man. Yes, man. Yes, sir.
If your lordship will dispose of the appeal, then there is no.
Yes, yes.
Yes, my lord.
Yes, anything else?
My lord, that the IA 8007 kindly allow, my lord. IA 8007 2023 for a rule.
We intend to condone the delay and dismiss your appeal.
My lord, I am living in this property, my lord. I have deposited 60,000 and I am living in the landed property. My lord, this is my own case, my lord. My lord, this is the lawyer case, my lord, my own case. I am living where I am going, my lord, in this area, my lord.
We can initiate contempt proceeding against you for making this submission.
No, my lord, no, my lord. No, my lord, kindly allow me, my lord. I have good grounds, my lord. I will see before the any good grounds and judgment, my lord. Kindly allow me, my lord. My lord, my property and 60,000 already mortgage after releasing the vehicle, my lord, by the Honorable High Court direction.
Page 226. Mr. Bhante, seizure and confiscation?
Yes, section 56.
56.
Section. The basic requirement is that the offending vehicle should have been used for the purpose of transportation of illegal forest materials, and that is admitted. Here, proceeding has been initiated against the owner of the Kenduli. That is a different proceeding. So far as confiscation is concerned, the only thing required for to establish that this vehicle was used for, and that is admitted.
Oh, no,
No, my lord. No, my lord.
just
No, my lord. I have good grounds because the Lord and Justice, Lord and single judge are not hard my lord.
Mute him.
Did not hard my argument, my lord. My lord, my lord, this is my good ground unnecessary 6, my lord, only. I am not agree, my lord. I am not applying.
It is a case of 97. It went up to the Honorable High Court once, then it was remanded. Again, the confiscation officer was reheard the matter. Appeal was preferred before the learned district judge. Then the Honorable Single Judge had the matter in the impugned order, dispose of this. So it is a law. For last 30 years, it is the litigation is going on.
The order was passed under Article 226.
Section 56 of
No, 226. 226.
Where is the confiscation?
So you have a glance at paragraph.
No, from the act, please tell us.
Section 56.
Section 56.
99. Let's see this. Because we will proceed to the process. Procedure, yes.
There is no dispute about the fact that the appellant is the owner cum driver of a truck bearing registration number OAC 4643, which was found loaded with kendu leaves illegally, which led to the seizure of the vehicle and T95 bundles of kendu leaves by the forest officials on 2/2/1992. Oh, stop. The vehicle became thus, subject matter of confiscation in accordance with the provision under section 56 2A of the Odisha Forest Act 1972. So stop. Section 2A, subsection 2A of Odisha Forest Act 1972 reads thus. So stop. Subsection 2-B prescribes the procedure for confiscating a property made under subsection 2A. So stop. From the records, there does not appear to be any violation of the requirements under subsection 2-B of section 56. So stop. The vehicle was ordered to be confiscated by the confiscating authority. So stop. The appellant's appeal and revision before the district judge.
No, if appeal.
Appeal.
First
The appellant's appeal before the learned district judge Cuttack came to be dismissed by an order dated 31/2009, passed in FAO number 123 of 2007. The appellant challenged the order of the learned single judge, order of the learned district judge before this court by filing a writ petition giving rise to WPC number 4550 of 2009, which has been dismissed by an order dated 4/9/2023. So stop. The said order of, next paragraph, the said order of learned single judge passed in WPC number 4550 of 2009 is under challenge in the present intra-court appeal. So stop. Next. Learned counsel appearing on behalf of the appellant has submitted that it is not in dispute that the vehicle belonged to the appellant, who was the driver cum owner of the vehicle. So stop. He also does not dispute the fact that the vehicle was seized by the forest officials laden with 395 bundles of kendu leaf in violation of the statutory provisions. So stop. He, however, submits that the petitioner is not even, that the appellant is not even a matriculate, and he was not knowing the consequences of carrying kendu leaves in his vehicle. So stop. In the said background, he submits that the order of confiscation was bad. Confiscation of the vehicle was bad, which aspect has not been duly gone into by the learned single judge. First off, he has further submitted that next. After having gone through the statutory provisions, materials on record, and considered the submissions advanced on behalf of the appellant, we do not find any merit in the contention that because the appellant was unaware of the statutory provisions, the order of confiscation can be said to be bad. First off, the facts, in view of the admitted facts, learned single judge has rightly dismissed the appellant's writ petition. First off, we do not find any merit in this appeal, which is accordingly dismissed. IA number, limitation control, दूसरा IA stands disposed of. Yes.
Item number 6. May it please, Your Lordships. Your Lordships, I am appearing on behalf of Mr. Shivashish Mishra,
On behalf of
Mr. Shivashish Mishra, the advocate for the petitioner. Your Lordships, he is not able to appear due to some personal difficulties.
what do you want?
He is unable to appear.
Due to some personal difficulties. Item
Shivashish Mishra.
and any other date, Your Lordship.
Tomorrow, as requested on behalf of the appellant, list this matter on April. We did.
Item number 7.
My partner in lordship, we are appealing for the opposite party in lordship. We are appealing for the opposite party on behalf of Mr. Somnath Mishra. We are taking up this matter the 8th April in lordship.
8th April.
Obvious.
Item number 7. May I please?
Yes.
My input order is at page 124, annex 3, my lord.
Impugned order is at page
124, my lord. Annex 3.
annexure 3.
Annex 3.
Annex 3, page 124, my lord.
Annex 3,
No.
124 is. Your appeal runs 65 pages.
My WA,
You are in 498,
my lord, 2020.
Here,
annexure 3 at page. Is that
Declare hard
page
copy.
30 or something?
My read appeal contents 138 pages, including annexes.
Is this WA 498 of 2020?
Yes, my lord.
Annexure 3 is something different.
Then my lord,
Padmanabh Pradhan.
yes, ma'am.
Limit that.
Then my lord, you will grant me some time to verify my.
Let us see our scanning is proper.
It is an impugned judgment.
Improperly scanned. All right. We will take up tomorrow,
Yes, ma'am, on Monday.
on Monday.
Ma'am.
Phase two onwards, some other discrepancy.
Just take it as an example. Verify. Why should this happen?
Monday. My host to have it on Monday.
Monday, because scanning is not proper.
Yes, sir. That's wrong paginations.
Item number 8.
Item number 8, my lord, I am relying my lord's judgment that part in W number 16 of 2024, my that has not yet uploaded, so
It must have it.
it will come next week any day, my lord.
It has been uploaded. It has been uploaded.
In fact, that's today morning I have verified it is not uploaded. Yes,
My lord. I have also
It will come on Monday.
Monday.
He is saying it has been uploaded. It might not have.
I have verified.
I am not disputing that, I have just verified.
So what is the number, please?
Why it will come on.
Tell us, may I tell this matter may come on Tuesday?
No, Monday, let it go.
Monday.
Then Wednesday, let's see.
Any day.
Wednesday, let's see.
No.
Any day.
Yes.
Any matter to ask you.
Just after 11.
Oh,
In the morning, I will.
all right. In the morning it was not.
Yes. Grateful.
Yeah, you must have checked up before 11.
Sir, I asked. Before coming to court, what I 10:30 I have said. Sorry. No. May I play on Tuesday?
No, no, what Tuesday already?
What next? What next?
Wednesday already. Wednesday.
Let's get for this. Item 9.
My lord, I am for the respondent number 1. If your lordship allow me to appear virtually.
Yes, yes, please.
Yes, lord.
Miss Malad, yesterday I was addressing that issue of registrations being taken in the midst of supply. And I am relying upon this reference. Let's. The first question which I was addressing is that the Honorable Single Judge in the judgment has taken note of the Honorable Apex Court's voice-known enterprises case to hold that since the registration was taken after execution of the work order, issuance of work order in the midst of supply, therefore, the remedy available under Section 18 of the MSME Act is not applicable for me, and my reference before that has been dismissed. Now, my lord, I have at the last. Lordship may kindly have that voice know that.
Yes.
Voice no judgment is at page 67 of the compilations which I have given to your lordship.
Yes.
At page 70, paragraph 16, the Honorable Apex Court has actually left this issue to be adjudicated by the larger bench. Lordship may kindly have that paragraph 16. At page
7.
My lord. At
Yes.
page 70, 70.
70.
My lord.
Yes.
However, at the same time, the largest question and issues whether in a case where the buyer is located outside India but has not availed the service in India and or done the business in India with the Indian suppliers and the contract was executed in India, the MSME Act would be applicable or not. And my lord, the second one, and or another larger issue that the case the supplier is subsequently registered as MSME, the council would still have jurisdiction are kept open to be considered in appropriate case bearing in mind Section 18 as well as the Section 8 of the MSME Act of this code in the case of Silpi industry and others. So this question that whether subsequent registration, another larger issue in this case, the supplier is subsequently registered as MSME, the council would still have jurisdiction or this has been kept open by that judgment. Now, subsequently, the larger bench decides the issue. That is that report at page 72. And it is also after the impugned order.
72 paragraph.
Yes, my lord. Paragraph 33 and 34. Following the above, may I please, my lord, please, paragraph 33.
Yes.
Following the above stated issue, it is held that a party who was not the supplier as per Section 2A of the MSME Act 2006 on the date of entering into the contract would not seek any benefit of a supplier under MSME Act 2006. A party cannot become a micro and small enterprises or supplier to claim the benefit under MSME Act
by submitting a memorandum to obtain registration subsequent to entering into the contract and supply of goods or rendering the service. If any registration is obtained subsequently, the same would have the effect prospectively and would apply for supply of goods and rendering of service subsequent to registration. The same cannot operate retrospectively. However, such issue being a jurisdictional issue, if raised, could also be decided by the Facilitation Council or institutional centers. So this issue under section 16 has to be decided by the arbitrator, because the 18 has two parts. One is conciliation, the other one is arbitration. Once arbitration start apply, entire arbitration act will apply. So this question, whether the subsequent, the supply made subsequent to registration can also be decided by them. For that, the reference would not be dismissed, my humble assumption. And that is how I am assailing the impugned order. The Honorable Single Judge also have taken another ground, that is a 4-member bench, and it violates section 10 of the Arbitration Act. May I just draw to that?
Where is the order?
My lord?
Where is the order of the single judge?
Single judge has page, it's page 35, your lordship, I think. It started.
Yes.
It started from page 29. The first ground which I have already addressed, the second ground is the 4-member, and it violates section 10 stands violated. Paragraph 11 of the impugned order. Regarding the objection on composition of council, as arbitral, it appears from the order and minor dated 23rd March 2022 that there was sitting held on 20th January 2022, and the council observed that conciliations between the parties had failed. There was direction to list this matter in the next sitting for arbitration. The sitting was held on 23rd February 2022, pursuant to notice. The order made was of adjournment in view of the productions, before the council of the order dated 14th March 2022 made hearing. What is clear is that the council consists of 4 members, commence arbitration sitting as appears from the minute stated 23rd March 2022. This is not permissible under 1996 Act, and no exception or contrary has been provided under 2006 Act for there being an overriding effect of provisions. So section 10 says it has the arbitration tribunal should be or member. My lord, in this regard, I have nothing to say other than that this is a statutory tribunal constituted by the state.
So where is that MSEFC case number 68? Where is the order?
My lord, order is on the writ application. There is an additional affidavit filed in the writ application bearing number 5935. In that, they have annexed that order. Order dated 20th January, my lord.
18th January.
23rd February. Order, my lord.
20th.
In the writ petition.
In the writ petition, there is an additional affidavit filed by the petitioner. In that additional affidavit, this has been annexed. At page
426.
Maybe around 436, my lord.
436.
Yes. And your lordship at the bottom, at the last order in 438 page.
It is 434. Oh, Director of Industries.
Yes, my lord. It starts from 434. And the last page is the sign of the members present, signatures. The lordship counted out is 4. So this, the Honorable Single Judge.
4 members are there.
Yes, my lord. This, the Honorable Single Judge.
23rd March 2022.
Yes, my lord. Well, this tribunal has been constituted by the state is notifying. I am MSMED department. Lordship, may kindly have the writ appeal page 54. This is the notification constituting MSEFC council. Now, if the state is constituting it at 4, actually it's 4 collectively is to be 1 counted as. There is no provision for dissenting view. In any view of the matter, this can be corrected by the state. And for a wrong composition by the state through notification, I should not be penalized. My lordship, kindly page 54. This is the notification of the MSMED department. Page 54 of the writ appeal.
Writ appeal.
Yes, ma'am.
So what is the illegality in this notification?
The Honorable Single Judge says that Section 10 stands violated, Section 10 of the Arbitration Act. Section 10 says the arbitrator must be odd numbers.
Your case is that arbitration has already commenced.
No, yes, madam.
Conciliation
has already over. Arbitration has already commenced. In the midst of arbitration, the buyer approached this honorable court, questioning the reference maintainability. And there are other lines of judgment which are says once arbitration started, like from that SBP in 2005 Supreme Court, we say once the arbitration started, 226 is not maintainable. And that's continue, that's the situation of law continue till 2022 and 23.
Yes. Yes.
May I please, my lord? My lord, the issue is there was an arbitration clause between the parties when we entered into the agreement. I am a government company. I am a central government company. When I entered into an agreement, there was an arbitration clause and he was not registered under MSN. So, Lordship, in a government organization, we have a different segment. Some job to be implemented by MSME, they have a separate category altogether. Now, if someone enters into an agreement with me while he was not a MSME unit, and thereafter he turns himself and goes back for a retrospective effect, this has in every judgment of Supreme Court.
No, he is not claiming retrospectivity.
Lordship, to
claiming
come,
that.
No, Lordship, what to come within the purview of the Act. Lordship,
We are coming back within 5 minutes, Mr.
Lordship.
Yes, Mr.
Yes, ma'am.
Item 9, sir.
My lord, the issue is when he entered into an agreement with me, that time he was not MSA. This is understood. Now, Lordship, kindly take my read. If your Lordship kindly takes up my read.
Yes.
If your Lordship kindly takes up my writ petition, I have also filed a Section 11 application before the Honorable High Court at Calcutta. Because I have a counterclaim at page 160, if your Lordship kindly see it. In 2021, page 160, I have also filed a Section 11(6). I have given him a notice under Section 21 and I have filed a Section 11. Now, Lordship, if your Lordship kindly turns to their page, if your Lordship kindly comes to the MSME order, if your Lordship kindly turns to page 153, which it's my application, which starts at page 145.
153 or what?
145 of the writ petition, my lord. 145 of the writ petition. Lordship, I challenged the maintainability, which my learned friend said that I have not challenged. I challenged the maintainability before the forum itself. I have been completely non-suited. Now, if your Lordship kindly come to page 141.
Yes,
Not
we accept your submission that you had questioned.
Now, Lordship, kindly turn to 140. They have completely made me non-suited. I have not filed my counterclaim there also. I have a claim against him. He has a claim against me. Even we can go to any third party, any retired judge of this High Court, and we can adjudicate our claim. Lordship, why he wants to go back there is, first, he have completely non-suited me. Now, kindly come to page 141 of the writ application.
Yes.
Now, kindly see the order. It was the order of the December 2021 when we could not properly fight that case because my office is situated at Calcutta. We were executing a project at Odisha. So that time we could not travel. We could not give instructions. We sought time. Now, kindly see the order. The
That is a different aspect altogether.
No, Lordship, what I was
That is a
trying to
different
show.
aspect.
Lordship, what I was trying to show, kindly see, at that point of time, kindly come to 142. The MSME, when they were in conciliation at page 142, kindly turn to page 142. They were completely aware that the High Court is in session of the Section 11 application. They are recording my submission. Kindly come to 142 bottom. The respondent has not filed any reply. The respondent has also filed one-page case detail of AP 538 of 2021 before the Honorable High Court Calcutta, stated same to be have been filed by them. However, neither the petition of the said copy nor order passed by the Honorable could be adduced. So, Lordship, when they were in conciliation, I moved for appointment. All I want is I am not trying to non-suit them. By these proceedings, they have non-suit me because reply not filed, counter not filed. Now, if they proceed and I don't file my counter and reply, counterclaim and reply, then Lordship, I stand nowhere. I'm a government company.
No.
So that is the reason why then I challenge that. See, maintainability, you are not hearing. High Court of Calcutta is in session. You are not hearing. Then Lordship, I became non-suited. I said, then kindly, this entire proceedings is going beyond the natural justice. So Lordship, then I knocked the door of the Orissa High Court and said, see, this is the kind. Now, Lordship kindly takes up to judgment, which my learned friend has relied upon. Page para 33 he has placed. This para 33 is completely in consonance with Vaishno judgment. If your Lordship kindly takes up Shilpi Industry and Vaishno. There are two judgments, Lordship.
But I have given in my compilation.
Yes, it
Yes,
is.
Lord. If you're, I would request my learned opponent friend to indicate Shilpi Industry page number.
It is there.
It is the
Page number, if you kindly indicate, my lords.
Please,
Para 26 of the Shilpi Industry.
Yes.
If your Lordship kindly takes up para 26 of the Shilpi.
Shilpi, my lord, starts at page 53 and para 26 is
65,
yes, ma'am.
page 65.
Yes, ma'am.
Yes, ma'am. May I place that para 26? Although the applicant claims benefit the provision of under MSMED Act on the ground that the appellant has also supplying on the date of making the claim as provided under Section 8 of MSMED Act, but same is not based on accepted material. The appellant in support of his case placed reliance on a judgment of Delhi High Court in the case of GET and D India Limited Reliable such and such on a judgment and marketing file. But the said case is clearly distinguishable on the fact that as such the said case, the supply continues even after the registration of the entirety and the Section 8 of the Act. In the present case, the undisputed position is that supply was concluded prior to the registration. The said judgment of Delhi High Court relied to the appellant also would not render any assistance in support of the case. In our view, kindly see now this is the view of the Supreme Court. In our view, to seek benefit of the provision under MSMED Act, the seller should have been registered under the provision as on the date of entering the contract. So this is the clear provision of the Supreme. Now this has been followed. This has been followed in subsequent Vaishnav. Now kindly read the paragraph 8.2. My learned friend plays 8.3, but 8.2 was the relevant paragraph. If your lordship kindly takes up that judgment. May I request my opponent to indicate the page number of that?
Yes, it is there with us.
Lordship. Now, lordship, para 8.2. If we read 336, a 9 line from the bottom, 9 line from the bottom of para 8.2. It is admitted position that in the present case, the appellant is a registered MSME only on 28/8/2020, which is 4 days after the entering into contract. Therefore, the contract was entered with the appellant was not MSME, and therefore the parties would not be governed by the MSME Act, and the parties shall be governed by the law of India applicable prevailing at the time of execution of the contract. Now, lordship, what is the provision? The Arbitration Act is embodied in MSME Act. Now, if someone is entering into contract while he is MSME, then I have a proper notice that I am entering into someone who has a statutory arbitration forum. Now, I have a choice to enter or not to enter. Now, when I entered and then you become a registered company and then you force me to a statutory arbitration, I might not like it. So, arbitration agreement, which is section 7 of the Arbitration Act, lordship, kindly see what is the concept. While I am entering into an arbitration agreement, I have to know and I have to be aware of the fact that I am entering into an arbitration agreement. Section 7 of the Arbitration Act says the arbitration agreement. So when I am entering with a party, that time I know that I am keeping my arbitration clause. But after entering the agreement with him, he is changing the position and the arbitration proceedings is becoming from a personal arbitration forum to a statutory arbitration forum. Can I be dragged into that? That's the simple question to be seen. So that's the reason why Supreme Court in all three said you have to have a registered contract on that date. Because moment I sign a agreement with a MSME institute or a company, then lordship, I enter into a statutory arbitration. So when I am entered into him with a different clause, I have entered with him, if your now lordship kindly takes up my writ application at page 42. Page 42. When I was entering into contract with him, at that point of time, page 42, I was entering with the arbitration clause that a retired judge of any high court will appoint a procedure we agreed upon. Now the procedure which I have not agreed, subsequently he registered himself into a statute and then he drags me to arbitration forum of that statute. Whether that is permissible or not. That is the reason why every court is saying at the time of entering contract, you have to be MSME. So that I should be fully aware that if the dispute arises, where it has to be sorted or where it has to be adjudicated. So when I was entering the contract, I was aware
All right, we have already made your point. We have understood what you want to convey.
So, lordship, that's the reason why I said for section 7 constitute the arbitration agreement. So, when I entered into an arbitration agreement with him is with page 42. That is this general clause of arbitration.
We will see.
Page 42 of the writ application. I have annexed that. So, that time I was aware that this is the arbitration. And now, subsequently, he registered. where I have no consent, I have nothing holding on him. Moment he registered, then Lordship, can I be dragged? I'm putting this question to myself. Can I be dragged to another arbitration forum?
We will see. We are not sure. We will examine the judgments and decide the matter.
Lordship, I'm much obliged, Lordship. This is the only point I wanted to make.
One reply, my lord, you have to reply. Section 16. It says it's not where any buyer fails to make payment.
We will examine. We have
Notwithstanding anything contained in any contract, and section 23. That's the.
You will see, he has also some point.
But that's exactly what I said. My case is that agreement will not proceed to this act. That's these judgments also decided in that last judgment at paragraph.
You will see the context in which that helps.
Admittedly, on the date of execution.
I didn't have the registration. I obtained my registration in the year 2015. The supply continued up to 2018, and I approached for the supply made between 15 to 18. And I am ready to confine myself to that 15 to 18.
All right.
Lordship, kindly take note of 2 days.
Well, basing
His
your
date
arguments
of registration is
transactions. My lord, you're basing your arguments on the transactions effected after 2015 in continuation of execution of contract.
Yes, ma'am. 15 to 18, the supply made by me. I am confining myself.
You are on supply.
Yes, ma'am.
Lordship, his date of registration is December 2015.
Yes, we understand.
He is admitted.
Lordship, yes, and Lordship, my agreement with him is 2010.
Mr. Counsel, we may commit mistakes on law, but we shall not commit any mistake on law.
My perception is just the reverse. So we assist on the court on
We
facts.
are going to commit some mistake on facts. That is your.
So that's what we say. We court are overburdened, so we try to place the facts. More.
All right. Yes.
I'm obliged. I'm much obliged.
Heard that counsel for the appellant. So and so, and Mr. Sri Shankar Banerjee.
Yes, my lord. Yes.
Counsel for the respondents. You are for all the respondents.
No, I am for the respondent number 1, man. For region roof construction.
I am for the.
Who's the council, my lord?
Who has represented on behalf, appeared on behalf of
The other respondents are state and council. I am appearing.
on behalf of the rest of the respondents.
Opposite part number 2 to 4.
Yes.
This is matter 4 weeks for orders. On judgment for 4 weeks.
Item number 10.
It was a pleasure appearing before you, lord.
Thank you. It's a good question. Yes.
May I please, your lordship? My lord, your lordship will kindly recollect yesterday the matter was taken up. This is with regard to the this is with regard to the issue as to whether there was a concession before the learned. This is with regard to the issue as to whether there was a concession at all before the Land Appellate Authority under the ODA Act, which has formed the basis of dismissal of my writ application.
You were of the view that that is not a concession.
Not obliged, my lord. That was the issue. Now, your lordship wanted to know that was mentioned that in accordance with the scheme. Yesterday, because of paucity of time, I couldn't show to your lordship the scheme. So this is a commercial complex
where your lordships have been pleased to hold that the rigors of regulation is little more strict, but the compliance has to be made. Now, my lord, here only just one fact situation I would like to point out to your lordship is permission was granted for a B+3 storage building having 88.32 square meter area, whereas the construction has been effected for a B+4 building having covering area of 166.73. And this is a 104% deviation. Now, so far as the scheme is concerned, I beg to draw my lord's kind attention to page 37. Page 37, your lordship. This is the scheme. Page 37. This scheme may be called the Scheme for Regularization of Unauthorized Construction 2019. Now, your lordship will kindly turn to page 38, clause 3. 38. Clause 3, your lordship, with regard to applicability. From that subclause 2, the scheme is applicable only to such unauthorized constructions that are structurally safe and do not affect any public interest or safety or interfere with any public activity. I was pointing out yesterday with regard to fire safety measure and other things, my lord, and non-availability of a parking at the basement, which is sine qua non. Now, my lord, your lordship will see clause 4, application procedure. Application procedure, page 39.
Case,
Madam.
what is the date of scheme?
I'm sorry, pointing out. This is 6/8/2019.
6/8/2019.
Madam.
And when was the construction made by him?
Madam, the construction was much prior to that. That was 1905-2009.
2009.
But the scheme came into vogue post facto and it was considered under the scheme. There is no dispute about such fact situation, my lord. Now, your lordship may kindly come to page 39, clause G. Certificates or clearances or no objection certificates, as the case may be, relating to fire safety in cases where the same is required as per the provisions of Odisha Fire Prevention and Safety Rules 2017, if any. Then restriction or regularization is at page 40, clause 5. That is, your lordship, clause A, where construction has been undertaken on the government land or land belonging to local body or land not owned by the person undertaking such development. Now, here two aspects: one, the frontage government land, and the other on the side, the DT land. Now, in the affidavit, he says that the DT land I have purchased, government land I have removed the, my lord, so far as the removed the encroachment. Now, the parking is not there. He says he has taken a parking lot on rent. So, whether that will form the basis for regulation, that will be also another aspect. Now, your lordship will kindly see, so far as the requirement is concerned, page 42, clause 6. Relaxation of planning and building norms. Therein, towards the middle, my lord, your lordship will find subclause A in the table, clause 2 commercial, and the fourth one is for malls, shopping complexes, mercantile buildings of height of 9 meters or more and less than 15 meters. Therein, up to 70% ground coverage, then minimum 3 meter setback at least on any two sides except front side. That is because of the fire safety measure, they have to move around if at all there is fire. 50% of parking requirement. So that parking is not there, which I was pointing out to your lordship. Then your lordship will kindly see page 44, my lord.
But suppose if a building was constructed
My lord.
without any parking,
My lord.
provision for parking, and it is impossible to have parking area without demolishing the entire building. Is this your case that the building will have to be demolished for having a parking?
No, my case would be that it may be approval may be for any other purpose, but not for a commercial complex. But it will not qualify for commercial complex. So approval can, as my friend will clarify. I am assisting the lordship, my friend will clarify. It can be for any other purpose, but not for a commercial complex. He may make it a residential or whatever is permissible under this field. So for a regularization is concerned. But here he took approval for B+3 with a specific square meter of area. Now he makes it B4 clause with a 104 violation, percentage of violation.
No, 104 violation is because of your subsequent scheme. When the mall was constructed, he had not violated. But after your scheme, according to you, the violation was 104%. So before the scheme, what was the violation?
The violation of the very construction itself, the building, the fourth floor has to go.
4 floors may go.
The parking is not there, so there cannot be approval.
Was there any requirement then before the scheme?
Yes, because that is the approval that is granted. So that has to be made. I'll just clarify.
Just let us be clear.
Mad.
Before your scheme came in 2019, whether there was any requirement of parking?
Yes, ma'am.
Huh?
Ma'am.
No, what you said, G+4.
G+4.
Approval was granted.
No, +3.
G+3.
Ma'am.
G was for parking.
Yes.
How?
Basement, that is B for parking. Basement was for parking. Let me just clarify, as your lordship was pleased to tell me a question. Then
let us understand. We will give you as much time as we are giving to him.
Sorry. Now, what will happen if there is a deviation? If the scheme would not have been there, there has to be a demolition. As your lordship was pleased to observe, there has to be a total demolition. That's all. But he has made a construction in deviation of the approved plan. So unless the scheme is taken ahead of, it has to go in its entirety. But he has completely deviated from what was approved. So he has accepted it, that approval. He has not challenged that approval. What has happened? He applied for a regularization of whatever construction he has made. Now in the meanwhile, this scheme came into vogue, and we are saying that the scheme permits this, so therefore this cannot be regularized. So in the absence of a scheme, the entire building has to go. But there has been a total demolition. Then your lordship will see page 44. That clause 2 in the left hand side column, and your lordship will find clause B, that is in the second column. Clause A and B rather. May I just to the lordship's kind permission place it, madam.
Yes.
Have the provisions, this is with regard to apartments and special buildings. Have the provisions of second staircase the existing staircase of minimum width of 1.5 meter shall be converted to fire staircase pressurized, fitted with smoke extraction system and fire resistant doors 2 hours rating. In case there is a single staircase, an external staircase fire escape of minimum of 1 meter width shall be provided from the ground to the top of the building, connecting all floors for the easy evacuation of occupants.
All right.
Then your lordship may kindly turn to the next page, page 45. Irrespective of the relaxation provided in this para, the accessibility of fire engines and firefighting personnel to different sites and parts of the special building shall be accessed by the State Fire Service Organization while issuing no objection certificate or fire safety certificate. The owner shall provide all fire prevention and safety installations, and that's there, madam. This is what I get to point out from the scale. Now, my lord, I'll only draw your lordship's kind attention again to the decision of the Honorable Single Judge. The Honorable Single Judge has not considered the other factual aspects which also was considered by the appellate authority, though, my lord, this so-called concession was one of the aspects appellate authority considered. The appellate authority also considered the other aspects. But this so-called concession formed the basis of a direction for regularization. That was challenged for the Honorable Single Judge. Now, the Honorable Single Judge decides solely on the basis that there has been a concession. That is at page 57, your lordship. And that part of the order of the learned appellate authority has been quoted, and it has been said that there is a parking provision made at the side on rent or lease, whatever it is. My humble submission of it, that will not satisfy the building requirement. So therefore, even assuming he has a parking.
This is your submission that the learned single judge has decided, treating the submission, your the submission made on your behalf to be a concession. And that is the only reason why
Other facets have not been considered.
or
But this is what I beg to submit.
okay. Yes. Yes.
May I submit?
Now let us know from you,
My lord.
what would have been the situation had there been no such scheme of 2019?
So far the submission made by my learning seniors.
No, forget this submission.
Yes, sir.
Please let us understand that what would have been the situation had there been no scheme of 2019?
The building has been constructed a lordship in my purchase land. No, so far deviation is concerned a lordship.
Mr. Baral,
My lord.
wanted to know, see, you have got approval
My lord.
to construct in a particular manner,
My lord.
right?
My lord.
Is it a case that you have not deviated from that?
Yes, your lordship. I have deviated.
You have deviated.
Yes, your lord.
Yes,
So,
you have,
my
you have deviated.
lord.
My lord's query is, if 2019 notification does not come into force, or it ceases to exist, or it did not come,
My lord.
in absence of that, what would have been the position and what action, possible action could have been taken by Berhampur Development Authority? That is
So the structure can be regularized on the under the compoundable
So what we
duration
understand,
of the honorable.
just a minute. So what we understand from you is
My lord.
that your construction was irregular
Yes.
and could be regularized
Yes, your lordship.
within the parameters laid down under the scheme of
My lord.
2019.
2019 scheme.
So for getting benefit of scheme of 2019,
My lord.
you will have to comply with the requirements
My
of
lord.
the scheme.
My lord. Yes.
That is the only question.
My lord. Only question.
So-
And in all aspect to satisfy the scheme, I have accommodated all the conditions, your lordship. So far parking is concerned, the basement and ground floor already used as parking, your lordship, what my lordship are not submitted. The basement parking is there, and after objection by the appellant, your lordship, on lease, we have acquired the land, 5,000 square meter land, your lordship, for the purpose also, for the purpose of parking, to avoid the traffic problem in front of the road, your lordship. And considering all these things, your lordship, if a lordship will go bit by bit in the appellate court order, lordship, everything,
Just a minute.
my lord,
The land which you have taken on lease,
please.
can that be considered to be a part of that building?
No, my lord, that can, but only for the purpose of parking, your lordship. I have basement parking. So far, traffic congestion in front of the government road, your lordship, as because the commercial building is a traffic congestion post, your lordship. So to accommodate the authorities as well as the public, your lordship, I have taken on rent, paying 50,000 per month to the DTL lordship by making a lease, your lordship.
Where is that land?
this land
No,
where commercial complex
no.
is standing.
No, my,
No.
yes,
In basement, you say that you have already parking place.
my lord,
Correct?
yes.
No, Mr. Counsel, we are satisfied that if learned single judge has taken that part of the submission to be concession, then that is not acceptable to this court. We can remand the matter back. Finally,
One more aspect, if some of the single judge also taken it off, this parking lot on rent will form the basis also. That is also not a correct proposition of law. And your lordship wanted to know what is the provision and what will be the effect if it is done in contravention of this approved plan.
no, that will be seen by the.
That is section 91 clarifies that. Section 91(1). There has to be a demolition if it is contrary to approval plan.
The lordship kindly, the appellate's court order, lordship, under annexure 6, lordship, the honorable single judge, lordship, after considering the entire submissions and the material available record, the what my land senior submitting that it is a concession, that is not there, lordship. The in presence of the authorities, the appellate authority has inquired about the matter and considering all these things, the order has been passed. And in both the order annexure 6, page 29, start from page 29, lordship.
Just a minute, just give it.
Lordship, page 33 for a moment. The authorities in appellate court, lordship, considering all these things, the direction was given. And here in the before the honorable single judge, lordship, the paragraph 4 of the order, lordship, kindly have glance. After perusing the appellate court order and after considering the submission of both parties, lordship, the paragraph 4, lordship, it is at this stage, Mr. Panigai, lawyer counsel for the Barampur Development Authority, the appellant, submit once such regulation is made, same may create a procedure precedence in other deviation, lordship. Keeping in this view, this court, while finding that there has been already concession by the Council for the Development Authority for no impediment in considering the case of the petitioner under the Sarvakema scheme, while keeping in view the private opposite have already made a provision for parking place, this court here also taking into consideration the statement of Mr. Panigai, counsel for that this parking place made available by the opposite parties is by available single judge. Conceal the matter, lordship, and in presence of a city planner, lordship, the order has been passed. The authorities, the officials of the appellate authorities, lordship, they are present in the appellate court, lordship, and participate in the hearing and considering all the inquiry and considering the scheme, lordship, the order has been passed.
So did you give an undertaking that your this building will have the character of commercial place till that
Yes.
agreement continues?
Yes, sir, lordship.
You have given this undertaking to the appellate authority.
Well, in view of the order passed by the honorable single judge, lordship, I will give, but after the order has been passed, lordship, this appeal has been passed and the order has been stayed. And so far, fire safety concern, lordship, the entire building has already 90% fire safety work has been done, lordship. But after 2017, the authorities sealed the building, that has not been completed, lordship. Every accommodation so far fire safety is concerned, 90% of the work by the authority, fire safety authority, lordship, that has been completed, lordship. Only 10% is left and the building has been sealed. For that, it is not possible to complete, lordship, to obtain the fire safety certificate from the concerned authority.
No, but if he is taking, just a minute, let us. If he is saying that parking space shall be available, no difficulty to.
My only thing is that your lordship will see, so far as the parking space is concerned, that is always my lord, a aspect depending on the owner who has given it on lease, but that will not be, I was pointing out, not that for the sake of-
Undertaking which he is ready to give.
my lord,
This is the undertaking which he is ready to give, that the moment the agreement ceases to exist, he will not use the building for commercial purposes.
no, that is true. And only I was pointing out that that is on the basis of approval, that your lordship will decide.
Mr. Misra, another aspect. He says that the basement is already used as parking place.
Man, it has to be a fresh consideration by the authority. Because they have to again see, because by the time the appellate authority consider it, there is no parking space. By the time the honorable single judge considers it, there is no parking space. Where otherwise the contention would not have been. Let me, my
Minutes from his submission
man.
that in addition to already approved basement parking, another space is taken in addition to this.
No, that is not the case for the honorable single judge or before the land appellate authority. Then there has to be a fresh consideration by the BD authority in consonance with this case.
Additional space, interim order.
But the interim order was passed on.
No, the whole building has been sealed under some order.
The building was kept inside the building were allowed to be taken away. A window was made. But so far as the ceiling aspect is concerned, that was done, my lord. No dispute over that fact.
No, but will you not allow him some time to regularize?
No, I am not disputing that. He has to again apply, then it will be considered in consonance with the scheme. I am not saying we are not here to just.
He cannot because the building is sealed.
Yes.
No, now I will do. But the de-sealing, he can furnish, we can de-seal it. What may give a
Mr. Misra, all right. Mr. Misra, appellate authority at page 36.
Miles.
While allowing the appeal,
Mile.
he has asked you to de-seal.
Yes, Your Lord.
I am not disputing that. A concession was recorded. That is what was challenged.
Not concessional lordship, the inquiry was made in presence of city planner lordship, the page 33 lordship kind of glance.
Let me.
Page 33, the planning member BDA Barampur was also present. So, the planning member BDA Barampur submitted that if any construction is not regularized in previous order, it can be regularized under Sarvakema Yojana scheme if the building is with far for area ratio. But in the instant case, as the appellant has encroached 23.32 square meters of the government land, that is a lordship, the step made in the roadside drain lordship, that has already been removed. Then it can't be regularized. It is the sin.
To get all those things done.
Fire safety.
Huh? 1 month?
No. Fire safety.
And parking also.
His 10 year lordship, maximum 10 days it will take to complete the fire safety.
We are giving you more time,
Fine.
4 weeks. Considering the nature of dispute emanating from the order of the Revenue Divisional Commissioner, Southern Division, Berhampur, dated 7/8/2019, and subsequent order of the learned single judge of this court, we deem it appropriate in the interest of justice to direct that let the building in question be de-sealed so as to enable the respondent to comply with the requirements for the purpose of regularization. Under which is that scheme, name of that scheme?
And that scheme name is
Case 37 LRC.
that is the
Scheme for
Scheme for
regularization
regulation
of unauthorized constructions 2019.
Stop. It has been stated by learned counsel for the respondent based on the instructions which he has received that the provisions as required under the said scheme shall be made available within 2 weeks. 2 weeks.
My life.
3 weeks. 3 weeks. So stop. Can someone visit?
Well, we have to inspect after he makes the provision.
Who will?
Not the authority that is
We further direct, comma in
and the secretary, the deputy and authority, the planning member, whoever for
peculiar facts and circumstances of the case, comma, that let an officer of the Berhampur Development Authority be deputed soon after 3 weeks from today to visit the commercial complex in question to ascertain as to whether the building deserves to be regularized or not. Commercial building deserves to be regularized or not. So stop. List this appeal on 5 weeks.
only thing I was submitting, if your lordship permits, he said he has made parking provisions in the meanwhile in the building itself.
We will. Building, Mr. We cannot.
Business parking is always
cannot
there.
see. With that building, he cannot provide parking on the 4th floor.
The ground floor, he has said he has done basement.
Basement
He said,
parking is there.
Saying that,
he's giving a statement to your lordship.
see, we have to see
That is
so many
there.
things.
That is there with plan.
Something we cannot compel him.
Mr. Mishra, have you ever seen this Ramalingam tank in Barampur? Have you ever visited?
I have gone to Barampur, but not
This
visited.
Ramalingam tank.
Well, if it is verified, I think most of the buildings will be
Very, very old. Very, very old structures would be there in and around.
We can see notice the bona fide.
bona fide. Because in Kotak, I don't think there will be a single building which is completely adhering 100% to the approved plan, be it residential, be it commercial.
Item number 11. Item 11.
Request on behalf of the bar. Secretary has come.
What happened? He's going to play.
After lunch, you also know that cricket match. So make practice of that.
We will see. Adjourn the matters.
No, we are asking the lordship to see that rest of the alone courts also cannot function after lunch so that.
Lordship will be captain of all the.
All right.
My lawyers have already done net practice, the lawyers have not done, so they may lose.
Apprehending losing from your lordships.
If the
We can. All right.
function, then everyone has to remain. If the court will function, then everyone has to remain present. At least government council.
See, there is difference between you and the court.
Yes.
All right. We get monthly salary.
That is why I also said we are also bound to.
We will see.
11 the time.
Item 11. My lord, item 11, day before yesterday, my friend gave me, actually he has served me, but it's not, not added to the file. So I was praying,
What do you want?
my lord, may kindly give me 1 week time.
As requested on behalf of the estate, this appeal on. On behalf of the applicant, this appeal on 1 week.
Item 12, 1 week after, man. 1 week after.
Yes.
Item 12.
May feel good. Malady, in fact,
Your income.
there was one was urgent yesterday. The other two are today, Malady. You have to assist your lordship. Malady, though Malady in the first place,
My lord, may I? Because I have been requested by the London Transport Council to request for an Passover. He's not here.
Let it be in the list, it will come again on Monday. Instead of an argument, let it be in the list accepts. If he has difficult, because he has to decide the fate. We are
Monday match order.
obliged.
Item number 13.
Item number 13, in fact, it's a batch matter. And in none of my cases, I have received a counter affidavit. They say that we have filed a common counter. But the copy and
Counter affidavit, your case may be decided.
and I have 15, 16 cases today, which is all these cases, in fact, the virus of a particular rule has been challenged. 2022 has been challenged. My non-tender appearing in some cases, I am also appearing in some cases. In my case, I filed a counter. The rejoinder has been filed. It are ready. But in case a copy has not been served.
I'll serve in course of the day to the councils who are appearing, except my senior counsel. I'll serve in course of the day.
How many cases are there?
Around 50.
Around, some of my cases also 15 matters have been listed today. I have 7, 8 of the matters. So I am giving the numbers. Let it be listed together. So which is the rule? That's teachers. In fact, right from 2003, there was a statutory rule 1993 rule, but they had decided by a policy decision that they will give contractual appointment because of the financial crunch. And in fact, after 6 years of completion of service on contractual basis, they have regularized the service. That is prior to 2013. But in 2013, they made for the first time under Article 309, in exercise of that power, they made a statutory rule. They will give contractual appointment on completion of 6 years, they will be regularized. But in 2022, which rule is now subject matter challenge, they repealed that rule, saying that whoever has been appointed under 2013 rule, they will be regularized, they will get all benefits, a promotion, small benefit, everything. So far as the person those are appointed earlier and their service have been regularized earlier on completion of 6 years, they have been discriminated. That is what the intercepts. They have tried to create a class within a class which is discriminatory because they are all teachers serving in different high schools of the state. They say that the earlier appointees could be regularized after 6 years. But under the 2022 rule, they say that the appointees of 2013 onwards would be regularized from the very first day, initial entry into service. So that the latter appointees would be treated as senior to the earlier appointees in the cadre. So which breeds a class discrimination. That is the point. And so I am entitled to a counter bill. Let them serve at least one copy so that I can have a chance to file a rejoinder.
Now, what is your stand?
Our standard was
Time of visit appears to be,
yes.
argument appears to be
Yes,
acceptable.
I will clarify that. In 2013, a rule was made by the state government for appointment of all regular posts on contractual basis. In that rule, there was a provision under Rule 9 on completion of 6 years of service, they will be brought to the regular establishment. So that part was
Just I am interjecting. Before 2009, 13, some persons might have been regularized, services of some of the persons must have been regularized. Yes.
Yes.
Regularized. So they would not have applied and there would not have been occasion for them to apply under 2013 rules.
Yes, ma'am.
Because they were already regularized.
Yes, ma'am.
So this subsequent rule is prejudicial. Otherwise, had they been knowing that under these rules, they should have applied and they should have been regularized after completion of 6 years, they could have applied.
No, madam, that is not the fact. Fact is that earlier there was no rule. All were appointed on regular basis.
The court is putting a very simple question. I was working on permanent basis upon regularization before 2013.
Yes, madam.
All right.
Yes, madam.
Whether they should have applied under 2013 rules or not.
No.
That's true.
That's the crux.
You are taking
That's
away the
point. That's the crux. Not, they are senior. Admittedly, they are senior.
That is what
No, they are trying. What they are saying, prior to 2013, two types of recruitment are there. One regular recruitment and another contractual appointment. Two types of recruitments are there. Those who are appointed on regular basis prior to 17.
So far as the regular recruitment is concerned, right?
Regular is different.
Yes.
That regular is different. Suppose some persons were appointed on contractual basis.
Yes.
And their services were regular before 2013.
Yes.
All right.
Yes, madam.
So after coming into force of 2013 rules, they would not have applied.
No, they have not applied.
They would not apply.
Yes, madam.
Yes, they would not apply. They would not apply. And why should they apply?
They will not apply.
All right.
Yes, absolutely.
Therefore, you took away the chance for them to have the benefit of 2013. All right.
Exactly.
And thereafter, you are repealing the rule
Yes.
and giving the advantage only to those who were appointed. Absolutely.
That's the point.
Excluding.
I'll clarify.
They repeal it in 20. Your accept is correct. That is the only point.
That is the point. That is the discrimination aspect. That is the only aspect. And you can take a policy decision. Why to go for this?
And simple thing, sir. After 2003, in between 2013, there was no regular recruitment. They all recruitment were made on contractual basis. That is what of the policy decision of the government.
Mr. Rautra, is it the policy in 2013 rules that all the appointments on regular basis would be first given contractual appointments?
No, they say, yes.
Just
Yes.
on contractual basis, they will be appointed, and on completion of 6 years, a formal order will be issued
Yes.
for regular appointment.
That's
Permanent appointment. Prior to 2013, all contractual employees, they were considered in a separate set of policies for regularization.
Yes.
Maybe pursuant to Uma Devi's case.
Policy 2003 that they will be appointed on contractual basis, notwithstanding the provision of the recruitment rule 1993, which was imposed, but they will be regularized at completion of 6 years and they are regularized. As rightly my Lord Chief Justice has asked, that is the only question.
2003, another policy.
Yes.
Yes, sir. Think over in the meanwhile. Yes. That is a policy matter. That can be taken.
Any date at 2 p.m. let's fix so that it can be.
Let's give me some time because I have to file a rejoinder too. Because
Rejoinder.
copy of the counter.
All right, list this matter on. When?
I think also could be accepted after 20.
First week of April.
First week of April. 9th.
9th.
Perfect.
It is all other left out matter. Some left out matter of the
Along with
we are giving this.
along with.
I have given a list.
So it is expected that the parties shall exchange their pleadings in the meanwhile. I have to extend.
Let these, some cases were missing. I have given the list.
So will come.
Yes, obliged. Obliged.
Item number 14.
May I please elaborate list. Madam, this is a PIL relating to missing keys of Ratnabandara of Lord Mahaprabhu. What is PIL? This matter relating to the missing keys of Ratnabandara.
Missing keys of Ratnabandara that has been done.
That has been resolved. Would your lordship see page 15? The prayer of the petitioner. My lords have read page 15. my lords.
Just, yes.
His first prayer is, my lords, direct OP number 1 to follow the procedure. There was a, my lord, my lord.
My lord, that is not applicable to this case.
My lord, let me just give it 2 minutes. If my lords have the prayer, my lords.
Yes.
My lord, he says direct OP number 1 to follow the procedure laid down under 3(4) of the Inquiry of Commissions Act. But there was a Raghu Ijaz committee to conduct inventory of ornaments, valuable and precious stones, and which are not made since 1978. And if my lords kindly turns over the page, my lord, direct the OP number 3 to hand over Ratnabandara to ASI for repairs. My lords have it not, these are the substantial prayers. Now this had drawn your lordship's attention in PIL 20481 of 2023. I'll just take 2 minutes, Lord. If my lords are kindly pleased to, it's order to them. If my lords are kindly pleased to look at, my lord, to para 16, page 9.
Yes.
Of the judgment, of my lord's judgment, coordinate bench judgment.
Para 16.
Yes. 16. Yes. My lord may kindly turn to para 16, page 9.
Yes, we are there.
Mr. Rautra has contended that one additional affidavit has been filed on behalf of the OP number 6 before this court. With the said additional affidavit, minutes of meeting of the SJPMC, that is the Sri Jagannath Temple Management Committee, held on so and so has been annexed. In the said meeting, the following resolution has been adopted in the presence and active guidance of the Supreme Engineer, Archaeologist G.P. Ratnaik. On scrutiny of the said minute, it transpired in detailed discussion on opening of the Ratnabandara. For the purpose of accurate reference, the resolutions taken in the said meeting is extracted here and there. If my lordships kindly turns to just reads the highlighted portion, my lordships have it.
Yes.
Mr. Garnaik, Superintendent said that the status of the inner portion of the Ratnabandara would be assessed through conduct of laser scanning from outside of the Ratnabandara, and report would be taken up by opening the inner Bandara during Rath Yatra next year, after making assessment of the inner status. That was part of his prayer, repairs. The committee accepted the proposal of Dr. Garnaik with the advice of ASI to constitute a technical team consisting of technical members nominated by ASI, including 2 temple surveyors and 2 technical experts, so and so, so and so. The superintendent archaeologist, however, informed that necessary machinery for conducting laser scanning has presently been put to use in Gandapur, Varanasi, where it will be mobilized to Puri for making necessary assessment of the Ratnabandara. So this is one part addressed. Can you look at the next part? Since no inventory of the ornaments stored in the Ratnabandara has been made for many years, it will therefore be necessary to conduct the inventory of all the ornaments of the lords stored in both the inner and outer Ratnabandara. The committee passed a resolution requesting the state government to constitute a high-level committee under the chairmanship of a retired judge of the High Court or Supreme Court to supervise the conduct. Now, my lords, may kindly lordships have looked at your lordship given order. Yeah, my lord, this is your lordship's order of 6th of March 2024. Following order was passed by this court on 16th of February 2024, the lordships have quoted that order. And then my lordship says at paragraph 3, page 3, Mr. So-and-so representing the state of Orissa has produced before this court a notification issued by so-and-so relating to constitution of a committee for supervising the process of implementation of the values, including the state of Jagannath Temple. The constitution of the committee is as under. My lords may kindly see below. After that, paragraph 4, the present content petition has been filed alleging disobedience of the order dated 29/9/23, passed in WPC number so-and-so. Under the said order, the state government is required to constitute a high-level committee under the chairmanship of a retired judge, either of the High Court or of the Supreme Court, to supervise supervise the conduct of inventory as well as determine the modus operandi and counsel for so-and-so, so-and-so. So, my lord, if your lordship now sees para 6, in our opinion, in view of the notification dated 2nd of March 2024, which has been produced before us, controversy does not at all survive. And if your lordship sees, my lord, no useful purpose shall be solved keeping the matter. And my lords may now see his prayers were threefold. One is missing key. Obviously, the other things are happening, so key is no more relevant. And therefore, in my humble submission, the substantial prayers were that because the key is not available, people can't go in, repairs can't be made, Ratnabhara cannot be assessed. All that is over now. What survives?
No, it is survive. My lord, my prayer is only limited to prayer 1 because prayer 2 and 3 is never praised. Can you see the order number 1 dated 25th of April 2023? Order number 1, my lord. Dated 25th of April 2023.
Yes, inquiry of commission. Inquiry of commission.
May I read, madam?
I know, issue notice on 1.
Yes, you are confining yourself to prayer number 1.
Yes, madam.
All right.
Notice is issued in the first instance only to the state of Odisha, OP number 1, 2 and 8, limited to the first prayer to apprise the court of the current status of the court.
Prayer is at page 15.
Yes, my lord. I am reading out the order. Order number 1, dated 25th of April 2023. Certain specific directions were issued. Limited to prayer number 1. So whatever my Lord has submitted, that is only to prayer number 2 and 3. That is now not relevant. My prayer is only limited to prayer 1. To follow the procedure laid down in Commission of Inquiry Act.
What is that? Tell us.
Yes. My lord, this matter relates to the missing keys of Ratnabhandara of Lord Jagannath. Subsequently, there is a commission. Now,
where is that commission?
Yes. There is a commission constituted by the state of Odisha.
So whether that commission is there?
It's completed. Yes.
It has completed.
Yes, my lord.
So what should we do? We should direct that commission which is which does not exist anymore to follow the procedure.
No, my lord. There was a commission constituted. It submitted report. It submitted report on 29/11/2018. Now that is not tabled before the Legislative Assembly. Now there is a detailed procedure mentioned in Commission of Inquiry Act under section 3, clause 4. May I read that?
You will see.
Yes. At page 14, my lord, in my writ application.
No, but now the report has been submitted.
No, my lord.
The commission has not submitted its report.
No.
No, the commission has submitted its report. Committee
That's not the order, my lord. The court said commission the current status of the report. They have not found the status for the last 1 year.
Let us see. Yes, what do you want?
Section 2, clause 4, man. I have put it at page 13.
Where is my copy? They have followed under. My mark. And take care of it. Supreme Court is best. No mandamus. Narayan Rao. Report is no more relevant. Need copies. Correct? Where is the direction?
Yes, so you want the report to be placed before the house?
Yes, my lord.
That is the only.
Yes, my lord. Because there is a detailed procedure laid down, how to deal with that. They are not following.
So that is to be produced before the, placed before the house. This is what you want.
Yes, my lord. And the people should know.
People may know, may not know, that's different thing. Yes, Mr.
No, my lord, the lordships have always taken a view, my lords, that these reports are meant for the knowledge of the government. Now, by the time the report came, the duplicates keys were already available. And therefore, my lords, the next two steps have already been decided to happen. Namely, how the inner temple will be supervised, how the ornaments will be inventorized.
But whether any commission was
My lord, there was a commission.
constituted under the provisions.
You are actually right. There was a commission. There was a commission constituted under the Commissions of Inquiry Act. It gave a report. And your lordships have held also that if by the time the report comes, there is some change in circumstance, etc., my lords, then the government will take a decision accordingly.
No, but this is the mandate of law.
Yes.
That you have to produce.
My lord, your lordships have
To
taken
place
a
that before the
Yes.
legislature of.
I'm grateful. I'm grateful. Your lordships have taken a view that shall here is direct. And this High Court has taken a view. Andhra has taken a view. Gujarat has taken a view. And in one of the later judgments, Lord, the Supreme Court has now said in 2022 that there can't be amendments for placing it before for the government to act or otherwise.
No, there is no, the court will not do that.
Yes, yes.
But the court may require you
Yes.
to place it before the house.
Yes, we are subject to the condition that your lordships are satisfied that it is necessary to do so.
Section 3.
3, which uses the word shall.
Shall.
Now, what your lordships have held is shall must be read as may. But there are judgments. If your lordship want, I will assist your lordships. But what I was submitting to your lordship is, what is the writ petition for? The writ petition is for a mandamus that the inner walls of the Ratna Bhandara and the jewelries in the Ratna Bhandara should be repaired, should be inventorized. Now, these are the two substantial relief he is seeking. If it's a PIL, and if it is for public interest, the larger public interest with the repairs and inventories, if at all. Nothing.
No, maybe
Yes.
correct.
Correct.
That if it is the mandate of the law, the state has to follow that.
But I will,
In public.
I will show your lordship some judgments which say, my lords, that if in the meantime there has been some change in circumstances, then it may not be necessary to proceed with the report. I will cite some judgments.
No, but what was the purpose of the commission?
The purpose of the commission was to find out where the keys are.
So whatever.
Yes, sir.
There must be the commission continued for how long?
Continuous year, November. June to November.
Therefore, should be placed. You give us the decision where it.
I will, your lordship may call it after a week or 10 days, my lords. I will file an affidavit to say what happened to that report and why it was, where it is.
Run counsel for the petitioner has confined the prayer made in the present writ application in the nature of public interest litigation to the requirement of the state government to submit the report of the inquiry commission before the legislature of the state of Odisha in accordance with subsection 4 of section 3 of the Commissions of Inquiry Act 1952. So, list this matter on. We have overshot the time. 2 weeks.
So 3 weeks.
3 weeks for learned advocate generals to address this court on the said point.
Lordship pleases. Obliged. I will pardon my lord, item number 16. Item number 16, there is a noting that there is a copy of the rejoinder not received. But in fact, I have filed on last Friday. May I file on to record and maybe take it out for Monday, this case. These are objections.
Similar item with one justice in light of this.
Did it come? Monday. My lord, item number 15, my lord. You lost 15 Monday.
25.
Monday on Monday, my lord. On Monday, 15, item number 15.
It will come on Monday. Request made by members of the bar, first half. Still, if there is any urgent matter, we can take up.
In fact, all these matters can have next Friday can be taken up because some cases we don't have any instruction or are directed taking instruction, others are criminal appeal 2-3 meters.
Oh, your request is after lunch you're going to start practicing?
Yes.
I thought maybe 3.
Otherwise, the bar cannot face the bench on the field.
Only we are practicing since long.
So you want to avoid facing us here now? Only one item, one probably they were supposed to get instructions.
Item number 1.
1 minute, so lawsuit said directed me to file an affidavit. I talked to the officer, they will say, but transfer it because there was a direction for transfer of the appeal, but in place of appeal, it should be revision. So I will take, they will do it, the lawsuit may grant me some more time to file that affidavit.
2 weeks for the 2 is allowed for learned AGA to seek instructions. Discuss matter on 2 weeks.
Item number 2.
Item number 2 will give submission by my friend. Actually, next week. The criminal appeal bail matter also.
Appeal bail matter. You are in custody since when?
9 years.
9 years.
That's the same order may pass because his case is that she will go on the head. Lawsuit can direct regular basis to hear this appeal. So the lawsuit can
The other appellant has been granted bail. My submission, the sole witness, which the testimony is there, so the matters there.
So if you agree, we can hear the matter finally, even that is setting.
Because the person who has been granted bail, he was holding an axe, there is no injury on the head by axe. Only blow by the crowbar.
No, what he's saying that witness,
Yes, sir.
his evidence is a little doubtful that he hid. Wife is being assaulted, he hid somewhere.
Next week, you also can hear the bail, if not,
Sometimes they want bail instead of acquittal.
Why do you want bail? Why are you interested in bail?
I will not.
Or at the maximum case, maybe we met out under part 2 of section
Yes,
304.
1 or 2, that's I'm saying.
That can be done.
Then my lord kindly fix a fix.
All right. This I'll do.
Yes, Lord, fix it.
And we can do that period undergone.
Yes.
One blow only.
Kindly.
List this appeal on 2 weeks for final hearing before this bench, along with children appeal number,
Lord, 11/4/9/2017.
only 2 appeals.
No.
Both the appellants in the same appeal.
Oh, same appeal. Oh. Very. We can dispose of.
Item number 3.
Wait, please, Your Lordship. File an IA for modification of condition number 15, para 15. There was a direction to take the child to Calcutta with his maternal uncles. But due to threat to my life, I am praying that any neutral place may be fixed. If they want to meet the child, they can come and meet at a neutral place. I have not received the copy, madam.
Give him a copy.
I'm serving it on court.
Get a copy of the IA number 24.
4 of 2020.
24
Madam.
Yes.
of 2022 be served upon learned counsel for the respondent or opposite party. What do you want?
Opposite party.
Opposite party be
PM.
a copy of IA number 24 of 2022 has been served upon learned counsel for the opposite party in the court. Mr. Officer, this case on 2 weeks so as to enable learned counsel for the opposite party to consider the said application and seek instructions.
Item number 4.
Oh, please.
For may I please, madam? Interim application for withdrawing one annexer, that is annexer 4, which is not at all legible, that's why.
What is not legible?
Annexer 1, I want to withdraw, ma'am.
What do you want?
Annexer 4 is not legible as per my lord's direction, my lord's directed to file a original. So original is not available with me. So I want to withdraw that annexer.
State government said that is
This writ petition is pending or it has been disposed of?
My lord disposed of with non-appearance of the petitioner, non-part of the petition. And the same appeal that the restoration petition is also pending.
Restoration petition is pending.
That is not in the board, my lord, but that is pending, my lord. That I have also filed in time, my lord.
only if it is restored, then only this will be modified.
My lord.
Ask the restoration application is to be taken up for consideration. That
is not in the board, my lord. But CMAPL number 578 of 2022 is pending.
then it has to come along with this.
My lord.
And only any modification can be.
No, by which order your application was dismissed? There is no
Order dated 29th September 2022.
29/9/2022.
Man.
IA number 14714 of 2022, in the court's opinion cannot be entertained in a writ petition which has already been dismissed for default by an order dated 16/2/2022. Sorry, by an order dated 29/9/2022. Mr. Officer and Counsel for the petitioner has stated that an application has been filed for restoration of said writ petition, which is pending. So, be that as it may, no order can be passed in the present facts and circumstances of the case. The present matter on IE number. What is your IE number? 14714 of 2022, which is accordingly discussed. Yes.
Item number 5.
Affidavit is not in proper format. Three days time may be granted to file proper affidavit format.
Affidavit additional.
Which affidavit?
Affidavit, I am asking.
Oh, yes. Right, right.
2 weeks.
Item number 6.
Lord, 6 can be disposed of in terms of the lordship class 1.
Yes. If it is agreed by Land Council appearing on behalf of the Land Council appearing on behalf of the petitioner states that in view of this court's order dated 6/3/2024 passed in CONTC number 1238 of 2024. This proceeding has lost its efficacy. Stop. Stands disposed of.
Its order can be kept on the record.
Item number 7.
May I please your lordship? IA by number 94/2024 has been filed 2 days back. It will come along with the IO and the same IA, so that matters. Copy matters. Okay. Yes, yes. Comment.
On what ground you are seeking review? You are seeking review
Yes, your lordship.
of, huh?
The petitioners are maternal grandfather and grandmother and grandmother of the child.
I pray
members
to
take up the matter at least by granting me 2 weeks time.
2 weeks time.
Yes.
You are for whom?
I am for the opposite party number 1.
As requested on behalf of opposite party number 1, this matter on 2 weeks.
You have filed an IA, another IA.
Yes, your lordship.
So give that number, then that.
94 of 2024, 2 days back it was been filed.
Give him a copy. Have you given?
Yes, copy I have given. Copy, sir.
For 2007.
Yeah.
Dredging and distillation.
So it was because it was notified.
So we'll call it again at the end of the. We'll call it again at the end of the board.
End of the board, the lawyers may not like to intercept. All right.
First admission item number 1.
Dispute arises out of a CPWD contract.
Just a minute. Just a minute. Sorry, I have opened different file. Yes.
Dispute arises out of a CPWD contract. And there being an arbitration clause in the contract, a notice was issued.
Where is that?
The notice, the arbitration clause is at page 17, clause 25.
Yes.
And thereafter, a notice was issued at page 37. That's a section 21 notice.
So is there any objection to it?
No, this is the first time it's been listed. So notices, the opposite party needs to.
Someone is appearing.
My lord, I can be permitted to appear to virtual mode, my lord. In this case, I have instruction to appear. I'll file my appearance memo and as well as
I'll take instruction in this matter. I'll make.
Take instructions come with the name of the arbitrator. We may appoint arbitrator
My lord, my lord.
as requested on behalf of. No notice?
Opposite party number 2 may need to be noticed.
Learn CGC. Mr.
SS Kashyap.
SS Kashyap accepts notice on behalf of issue notice to members. Item number 2, speed post.
My lord, I am for open over 1 and 2 only.
1 and 2 both.
Measurement.
The Lordship may fix a early date so that the arbitrator can give.
4 weeks.
Lordship, deeply obliged.
Item 2.
Petitioner in item 2 minutes. This is an arbitration petition under section 29A of the Arbitration Act. And what I'm seeking is an extension of the time frame for the purposes of completion of the arbitration. The parties had
In fact, that dispute is yet to be decided, that legal question. So today a matter has been fixed for judgment. Yes, sir. The judgment we are not going to deliver today. I'll be delivering the judgment next week. Because in the meanwhile, the party in that case.
This is the judgment.
This is the Lordship are referring to.
Yes.
In that ARBP 25 of 2007, which your Lordship had heard. I've just given a copy of the order.
No, but Mr. Sashwat Acharya was saying that there are 2 decisions of this court.
That is what we were just discussing with the learned senior as well now. There is a Justice Biswanath's judgment.
Do you have those judgments?
Yes, my lord.
So you will decide your matter after 2 weeks.
My lords, may I only request, because my learned friend is showing the decision of your Lordship's court. My only issue, and that decision, if your Lordships were to see, they have relied upon 2 decisions of the Supreme Court. That's a decision which is
Your voice is not clear. There is some problem with your connectivity, Mr.
Is my voice clear now, my lords?
Yes, now it's clear.
Because what I'm saying is that, my lords, if that is the decision which is being right now shown to your Lordship, my learned friend is right, that is the court relies upon 2 decisions of the Supreme Court, which are on entire.
Again, you are not able to.
I'm sorry, my lords, am I audible now?
There is no clarity in your voice.
Am I audible, my lords?
Sometimes you are audible, sometimes not.
I'm sorry.
Yes, now audible.
Lords, all I was saying is that the decision which is being shown to your Lordship is right now of your Lordship's court relies upon 2 decisions of the Supreme Court, which is on entirely different footing. That was, my lords, on a section 34 question.
We will see. The judgment I would have delivered today itself, but because they were relying on, and rightly, whatever decision has been taken, I had to consider that. So I'll consider those decisions also, and then I'll render my judgment next week.
May I only request one thing, my lords, because
if you have any judgment of Supreme Court, we have all the judgments of the High Courts. But if you have any decision on this point, on the interpretation of the word court under section 29A, then you may rely. Otherwise, there are so many decisions of various High Courts.
Yes, sir, right, my lords, and there is no Supreme Court decision, unfortunately. The only issue, therefore, my lords, would be that the 2 Supreme Court decisions which your Lordship's court has actually relied upon, whether they would be relevant for the purposes of.
That we will see. There may be a requirement of referring the issue to a larger bench. We don't know. I have not seen the decisions. And Mr. Please see the fairness of the counsel that he is not relying on these decisions. He is just giving those decisions which are against him.
Absolutely, and I would have done the same. I had come prepared.
Yes.
Just one submission, if it will meet with your Lordship's and concurrence, is that in case if it requires, my lords, that on this decision we must address your lordships will keep the matter next week, we'll address. I have no difficulty, I'm ready to address your lordships now, if it requires to addressing your lordships. But if your lordships, after having gone through, believe that, my lords, we need to address, my lords, please allow us that liberty.
I can assure you only one thing,
Yes, my lords.
that if I accept what is being argued by you, then your assistance will not be required. But if I am going to take another view, or if I am going to refer the matter to a larger bench, of course, I'll hear you, I'll have the benefit of hearing you also.
Like, my lords, I'm grateful to your lordships, my lords. That is the only indulgence that I was seeking, my lords. Much obliged.
Well, the only prayer we can then say is, my lord, if both the matters could be tagged up, if in case whenever your lordships are deciding.
No, we shall not tag up, because that is for judgment, and this is still for that will come for judgment.
Oh,
I will
well,
see these decisions.
It is given copies, my lord. Just given copies. That's a list of citation which we have already given, which your lordship already had my lord, we have also given the single judge's order.
No, I had prepared a judgment, but because you wanted.
I understand, my lord. On the section, my lord, we are satisfied on that particular day that the meaning of unless the context otherwise.
Yes, that is the only thing.
Which is what a lot of
that is
high courts have decided on.
But even then, if we have to take a different view, then a view has already been taken by a court.
I concede.
The matter will have to be referred to a larger bench.
There has to be a pre-assessment.
May I only say this much, my lords, that there may not be a requirement, and that's the reason I was addressing your lordships, that there may not be a requirement for a larger bench if, my lords, today it can be demonstrated that the decision of the learned single judge, my lords, of your lordships court has actually come to a different conclusion basis only two decisions, and he did not have the opportunity. The court did not there have the opportunity.
Therefore, that decision may be incorrect. We don't know. But the law which has been laid down may be incorrect. But there is something called judicial discipline. So we follow that.
Lords, if
it will all depend. It will all depend on. I'll see the judgment first, and then.
Very
if required, I will hear you.
But could it be listed on the same day, my lord, so that we all have the.
This Friday, I am not here.
Well, any day the lordship is fixing that for judgment, if it can be listed on the same day. As a lordship, please.
Both the cases will be on same day.
Lordship, please.
5th of April. 5th of April, Mr.
5th of April, my lords. Great.
Item number 3.
Pardon, my lord, I am here for that order item. I am here, but I cannot understand which item is going on. So
You are in which case?
criminal CRB is 134 of 2000.
Arbitration.
No, the orders to tackle none.
Item number 3, ARBP 9 of 2023.
If I may please, your lordship. This matter is with regards to the appointment of the umpire, your lordship, which unfortunately has not been able to be completed within the time frame provided by this honorable court. The petitioners have appointed an arbitrator. The opposite parties have also appointed an arbitrator, but unfortunately, the umpire has not been decided as of yet.
Lord, I appeal for the respondent in this matter. Lord, in my respectful submission, this application itself is not maintainable because under 11.6, Lord, there is no failure on the part of the two appointed arbitrators to appoint third arbitrator. In fact, they have not been able to meet. And that can't be a ground, my lord. If there is a disagreement, only then an application under 11.6 would lie. There is no today there is no decision. So all that has to happen is that both the arbitrators are requested to meet and appoint the.
As on date, your application is not maintainable. You can file a fresh application later.
But what my humble submission is, your lordship.
Your application is defective as on date.
That I humbly bow down to your lordship.
Yes.
There is some defect as of today, your lordship.
Yeah.
But the problem is, your lordship, since the last 1 year, the matter is being dragged on and an umpire is not being appointed.
That
Fault, your lordship, can be attributed to both the parties.
Yes.
What I humbly beg before your lordship is that at least some indulgence may be given from this court, even if the matter is not disposed of.
Indulgence, this is defective.
What my humble submission, your lordship, is that the matter may not be disposed of as of yet. It may be kept pending, and a direction at least may be, a date may be fixed.
Let the defects as pointed out by the stamp reporter be removed within 1 week, during which this application shall stand dismissed without any further reference to the bench. Yes.
Item number 4.
I am obliged.
May I please? The matter relates to appointment of arbitrator, my lord.
May I suggest something, Your Lordship? They sent us a notice with a proposal that Justice A.K. Ratha is an arbitrator. We are agreeable, let him be appointed, both parties.
Take care of order the order. All right.
Item number 5. Item 5.
Sir, kindly request is so passive. Mr. Palisaman is like in another.
This is matter on Friday next. So, 2 weeks. Next Friday, I'm not. 5th hour.
Item number 6.
And in item number 6, 7, and 8, power of Mr. Rath and associate may be ignored.
Power of
Mr. Rath and associate may be ignored, my lord.
For the respondent.
We are not in the panel of wisdom only. So I pray that the matter be adjourned to some other date so that they can choose a lawyer of their choice.
Next week, next Friday.
matter on 2 weeks as requested on behalf of the parties.
Power of Mr. Rath and associate may be ignored.
That is not there. So
They are appealing for the
as requested at the bar. Will that do?
Item number 7.
Posted for 2 weeks,
2 weeks.
Item 7.
My lord, 6, 7, and 8.
7, 8, 7.
6, 7.
6, 7, 8.
Item number 9.
May I please? This is there the appointment of arbitrator, my lord. At page, annexure 1, at page, running page 14, clause 26. There is for appointment of arbitrator. All disputes and differences between the parties hereunto in any way related to the connected with the premises or the building and or agreement, anything done in persons thereof shall.
Where are you reading? Page 26.
Yes, page 14, my lord. Page 14, running page 14.
14.
My lord. The agreement clause 26.
Yes.
Place for non-page 14. All disputes and differences between the parties hereunto in any way related to.
Yes.
My lord, I am appearing for opposite party. My lord, I am sorry that due to illness of my client, he has not come to swear the affidavit file counter. But I have instruction that he is with the petitioner for compromise. And if your lordship come to the fact, my lord, after 2019, first time they have issued notice in 2023. And they have not also suggested any person for to be redress the dispute.
File your reply.
My lord, the question is, without certificate of dues, they went to the bank, got the entire loan and received the loan amount. And the dues are true. Therefore, this
clause will have to be invoked.
Yes, yes.
We will have to have some opportunity to respond.
We have issued notice. They didn't respond also. Annexure 4, real conditional grants.
Mr. You have filed an application for appointment of an arbitrator.
Miller.
He has a right to respond to that.
Miller.
All right, let him do that.
No, this court has to appoint arbitrator because
They did respond to my
Before
notice.
the court appoints an arbitrator, the court has a duty to hear the other side also.
And in the meanwhile, court dates have been given and two advocates appear with both from the both parties. And last occasion, your Lordship Kalegas, they told if unless counter is filed, this court is competent to appointment. And today he is taking some other plea.
We will see next time.
That is what I am
On
submitting.
behalf of the respondent. Respondent lists this matter on 5th of April.
But in the meanwhile, if any counter shall be filed, in the meanwhile. Yes.
Even without counter,
Item
the
10.
respondent, said respondent shall be at liberty to file counter affidavit in the meanwhile.
Item number 10.
Item 10, I am appearing for the opposite parties. I will let the matter be called next week.
Why?
I have sought for certain instructions.
It's appointed arbitrator only.
Yes.
No dispute about that.
No, the clause is there. No, this notice has also been sent.
In the meanwhile, select an arbitrator. Tell the court.
Yes, that is why I am praying for a sort of.
As requested on behalf of the respondent, number
1 and 2.
1 and 2. Discuss this matter on 2 weeks, 5th of April.
Item 12.
11 also same. 11 also same.
May I please? Worship, in item 12, I am appearing to the respondent number 2.
Item 12. All right, give your slip.
What?
Please give your slip. Name
is different. Item 3 just called out.
Yes, ma'am.
Worship, I think Mr. Probably counsel for the petitioner is not there. Probably counsel for the petitioner is not there, is not in DC.
Is there? Is not there.
One counsel maybe.
There is no representation on behalf of the petitioner. This matter on.
May I pray, Lordship? Lordship, can it be possible if he joins, then
It will come on 5th.
much obliged.
So it is a request from the members of the bar
Much obliged.
that the court should rise early.
I understand there is a cricket match. And
Yes. Item number 13.
Lordship, it seems counsel for the petitioner has already joined.
Yes, my lord. I'm on VC, my lord. I may be excused. Here is a case of an appointment of an arbitrator. So there is evidently a dispute. So I pray the honorable court to appoint an arbitrator.
Appointed.
Yes.
But which arbitrator?
Should the amount of dispute is around 3.5 or 4 crores around. Should any retired High Court judge?
You suggest, why should the court?
Justice A.K. Rath or Biswanath Rath or Judge.
Take one name. The court will not select.
Whatever my petitioner, counsel for the petitioner agrees.
Yeah. Any name, sir?
No any.
Sir, okay, Biswanath Rath.
Biswanath.
Much obliged, Your Worship.
Item 13.
Obliged, my lord.
Item 13, your lordships. In fact, this is an application under section 29A. And I know the development, but what actually is happening, the award has been passed yesterday. So this is the situation now. And that judgment, in fact, I think one of the judgments only, there are two judgments. One is of Justice S.K. Mishra and one is Justice Biswanath Rath. I think what probably stares at us today is Justice Biswanath Rath's judgment. I have them, of course, in the soft copy. What has not been addressed in this judgment is that the definition clause always starts with a reservation, otherwise the context requires. That argument was not taken by this, in this judgment.
In fact, I was also of the same view because I had missed that clause earlier. The opening words of.
In fact, I have already argued that point in an earlier case when Justice Rafiq was here, but He said, no, I am convinced that this will be here. So he did not really address that point. And that time we used to have the extensions done here. But as your lordships are going to rehear the matter, so.
It seems that the matter may be required to be referred to a larger bench.
Yes, I believe, because this judgment also does not really concretely answer the way we had convinced the courts to. But now our problem is that our award has already.
I have examined all the Supreme Court's decisions.
Yes.
On this point, there is no direct decision.
Yes, we have also.
And there are consistent views of almost all the high courts.
Yes.
While referring to that clause.
Yes.
Unless
Specifically, the Delhi High Court judgments are very clear.
And Bombay also.
Yes.
Patna also.
Yes. In fact, this judgment I have, if your lordship wants to have a look, I have.
The judgment is there.
Lordships. So we.
All right.
It's an opposite party counsel, Mr. Padhi is also there. I think he's there online. So.
All right.
My lords.
So he
My
has
lords, it's a settled position now. What has come, my lords? So therefore, my lords may, depending on if a larger bench is constituted, of course, it's a different.
But the view this way or that way, I don't know how it will affect us. That's the because the provision of section 29A says that we can file an application here and continue the proceeding. So we had filed it here and we continued, and the award came.
And the award has already come, my lord. So
yesterday it was, and today.
Maybe my lords may.
See, you will have to examine. Next time you may address on one point. Please keep that also in mind. That by the amendment by which section 29A was inserted, by the same amendment, the word High Court was substituted in place of Chief Justice.
Chief Justice.
All right. So there it's still High Court, not court or anything. So here, either High Court or Supreme Court could have been mentioned. This may be a counter argument. So we also argue against and see in our favor at times. So please develop that also, because if larger bench has to consider, then it will consider that aspect also. That aspect has not been considered in any of the decisions of the high courts.
In fact, Allahabad High Court recently has referred it to the larger bench. There they have. So we'll check up what's been the development there. Why did they also go?
But this aspect, you please try to address that.
We should
the amendment.
That's also something. I could do that. You could not have.
No, it seems I am incorrect, because this
No, in a institution, this will not come into force. Few provisions will not come into force.
Section 6. There was amendment by Act 33 of 2019.
Few provisions have not come into force.
Where the Chief Justice was substituted by the Supreme Court or High Court.
I think the Delhi High Court judgment,
And 29A was in 2016. So this was prior to that.
some amendments also.
Please keep that also in your mind.
I think the Delhi High Court judgment kind of addresses that, because I think it takes into picture also the ad hoc appointments which are being made outside the court, for which we still are going to the district court. But when it's an appointment under section 11 here, that's exactly where we are coming here.
So there can be one view that once an arbitrator is appointed in exercise of power under 11(6), the High Court, for the purposes of the entire arbitration proceeding, becomes punctus officio. So now everything in respect of that arbitration has to be done outside by whatever method, either by going to the court within the meaning of under section 2, or to be decided amongst the parties. But they, in no case, any dispute should come to the High Court. So this can be one view, that the purpose is, the role of the High Court is only to appoint an arbitrator, and then the matter may go to the court. Court means court.
Yes, because there are other provisions also during the arbitral proceeding where
the High Court is kept away.
Example 14, where High Court will be kept out. So we'll address.
Just to assist your lordship on this, what felt from a lordship that Chief Justice was saying by the High Court, that has to be read along with 3 capital A, which says that because those provisions are yet to be
notified.
But what basically we are moving into a kind of a future regime where they would not want the High Court to appoint, but it would be the institutions appointing in an administrative manner. If my lord would see 3 capital A, where those institutions will come in, like we have in Bombay, those institutions, where the institution itself appoints. So basically, once those provisions are notified, then we would go into a era where there would be minimal intervention in appointments. So the institution would themselves appoint, and thereafter this 28A would come in, where the district will take a call whether the extension is to be granted, whether removal is to happen or not.
Because removal is still happening under 14, removal is still happening in the district court, even if this court appoints. So that can be a.
The logic given by the High Courts, High Court Delhi and Bombay, the logic is, and Patna High Court also, that it will be an anomalous situation that the High Court appoints someone and the court shall have the jurisdiction to substitute. So
the counter
functions are different.
But the counter argument to that is, under 14, the district judges as such have the power to deal with such an application.
They exercise judicial powers.
Yes.
But here you are saying that High Court is doing just administrative thing of appointment of an arbitrator. No adjudication or nothing like that. They exercise that power. You will see.
This provision which is yet to be notified also has to be probably factored in by deciding whether 28A the power will be with the High Court or district court.
We will see, keep that in mind.
Yes, because that I'll agree with Mr. Mishra, because there we are heading into something completely purely administrative. The court may not even sit over it. And there, obviously, we will have to go back to the district court, going back to the same definition.
Commercial court there. So it would actually be a civil judge,
Senior division, which again is a problem in a lot of
that court.
Because of the lack of,
yes,
training.
exposure, yes.
Yes.
That's
And then
We also face,
we will discuss, we can discuss it.
we also face some problems with our judicial officers face.
No, but if we can discuss this here before my lord, because since my lord is into this in an informal manner. There is a problem in our state here. The civil judge exercises power under 34. The appeals go to the district judge. Now, this has come in the last 3 years.
No, whether that expression has been defined, has been dealt with or not.
Yes, yes.
The principal judge of civil jurisdiction would mean district judge, I think. This is the.
But then we have a judgment with here against us, and then that got confirmed also in Supreme Court. So there was
This is the view of, that is the view of Supreme Court. That the district judge is the.
After the commercial
yes.
came in, the notification lies with the High Court and the government. The High Court, in consultation with the government, notifies the commercial court. So here in Orissa, that administrative decision has been taken, and they have notified the civil judge, senior division, and the commercial. Then 37 would go to the district judge. The problem that we would face in the next 2-3 years would be 37 orders would then come to the High Court, because possibly they cannot go to the Supreme. We have a writ petition in, probably we are looking at those writ petitions. So then that could actually further delay the activity. So it would be counterproductive of what actually the commercial court. So this can actually be resolved by an administrative order by appointing additional district judges as the commercial court.
It is good that I will be having your assistance in this.
In fact, this is something which we wanted to.
That will have to be resolved.
Otherwise, the High Court would be flooded with writ petitions, and it would be counterproductive to the basic Commercial Courts Act for which it came in.
My lords, my appearance may be recorded.
Yes, sir. Item number 14. Next, Lordship. There is a petition to appointment of arbitrator, Lordship. Lordship, on the last occasion, Lordship had directed to appoint an arbitrator. Appropriate order will be passed for appointment of arbitrator, because topic party not appearing despite sufficiency of notice, Lordship. And as far as the arbitration clause is concerned, it is there at para 6 at page number 25, Lordship. Who are they? Sorry, my lord. Who is the opposite party? Odis Smart Services. Odis Smart Services Private Limited. He is the principal, and then I was the agent, Lordship. And there is a dispute when there is some kind of indifferences. That's the reason that particular agreement was terminated, and there was an MOU that it will be terminated, and he is supposed to pay me 28 lakh somewhat, and he has failed to do so, Lordship. Kindly come to the page number. I'm giving one more chance. Whether the notices are going to correct address. Yes, my lord. That is the address, Lordship, and we have got the address from the agreement itself, Lordship. If Lordship will come number 14, there we got the address, Lordship.
And also on the MOU at page number 22, there is also same address, Your Lordship.
There is a typographical error in order number 3, dated 1/3/2024. 1/3.
My lord.
Last order was passed on 1st of March.
My lord.
1/3/2024, wherein quote unquote shall constrain has been typed in place of quote unquote shall be constrained. Stop. The said order shall be read accordingly. Mr. Raghuveer, Justice Raghuveer Das is taking up matters.
I'm not sure, my lord, whether Raghuveer Das is taking arbitration or not. Sorry, my lord. And it is my claim is of 28 lakhs, Your Lordship.
So,
Your Lordship may.
I'll see. Please, you also suggested some name.
My prayer is to appoint one retired district judge, Your Lordship. If I may, retired district judge, Your Lordship.
District judge.
District judge, because the quantum is only 28 lakhs. So, if Your Lordship will please to pass, my suggestion would be Mr. Gayatri Panda, Your Lordship. He is in the panel. I got that list of panel and list of retired district judges, Your Lordship, from the arbitration center. There, panel number 7, Your Lordship. His name is there. Mr. Gayatri Panda.
Today also there is no representation on behalf of the opposite parties. Stop. Do you have his email ID or something?
No, my lord. I
must be having. You are dealing with him.
email is there, but I got the address from the that agreement, Your Lordship.
From
the agreement, I got the address. So now it is.
So agreement. Therefore, I was saying that agreement was entered when.
My lord.
Agreement was entered into when. And this is your responsibility to ensure that the notice is served on the opposite party. Please ensure that the address is correct. Inquire and tell the court.
Lord, we have already sent, I mean, prior to coming to this court, my lord, we have already sent a notice, arbitration notice. Then subsequently, again, it was sent through this honorable court after filing of this case, my lord, and it is sufficient. And we have also given that tracking report at page number 33, at annexure 5 series, my lord, that the item is delivered confirmed, your lordship.
There also there is no representation on behalf of the opposite parties. Despite service of notice, they are the vendors.
Item number 15.
May I please? I humbly pray, my lord, for appointment of arbitrator for adjudication and settlement of the dispute between the parties to the contract. Contract agreement is found place as per the annexure 1. When dispute arose between the parties, the petitioner demanded for appointment of arbitrator, but he has failed as per the arbitration clause, which is found place at page 48 of my lord's brief, under special conditions of contract, that is clause 45.1. Page, my lord, 48 of my lord's brief. Towards top. Under clause 45.1.
Yes. So it's for the other side.
My lord, other side, just like previous matter, though the service has been made sufficient, but the opposite party has not yet appeared. Last occasion I came up before the bench of your lordship, and which I prayed before your lordship to get the matter adjourned to give a chance to appear for the opposite party. But he has not turned up.
Is this matter on? As there is no representation on behalf of the opposite party. Opposite party, only one.
One opposite party.
Opposite party, despite service, when service of notice.
For orders, item number 1, CRREV 134 of 2000.
In this case, both the petitioner and opposite party were dead. They filed the memo.
It has been stated by London Council, stated at the bar that the petitioner and the opposite party died during the pendency of the revision petition of this application stands awaited.
Item number 2.
My lord, this revision is directed against the order of conviction, my lord. Though I have tried best, my lord, to send the letter to the present to petitioners, but the letter received, but none reply has come. No one's reply has come. The case is well a very small matter, my lord. This is though conviction is under section 395. Out of 4 accused persons faced trial, and the Lawrence trial court convicted 4 accused persons. They filed appeal. In the appellate court acquitted 1 accused person on the ground that against that accused person there is absolutely no evidence. So for the 3 accused persons convicted in this first revision, 2 appeal petitioners are there, and my friend has filed another revision for another 1 accused person. So for these 2 accused persons is concerned, against them the Lawrence appellate court disbelieved the identification and convicted only on the basis of 2 saris, 1 from each appellant petitioner. 2 saris, my lord.
Yeah.
those were identified by the witness. On the basis of that identification of Sari, these two petitioners convicted and raised sentences for 5 years, my lord. The record reveals, my lord, till filing of this revision, the present two petitioners were there inside the custody for about 2.5 years, my lord. I have prepared a very small note. If you lordship, today is not possible, next time I speak also. Finally, please.
So what do you want?
This is the fact, my lord. This is my case. If your lordship today here, then my brother is saying for
Your lordship, actually, we have also tried to contact the petitioner, but we are not able to get any information on him, your lordship, and
So don't press it.
we have also
Unless
prepared
we
a short.
don't know whether he is alive or not.
my lord.
We don't know whether the petitioner is alive or not alive.
The letter received by them, I have verified this track report, but none contacted us. I don't know that
He is not interested. It's not an appeal.
My lord,
Revision.
so far revision is concerned, my lord, our duty to place the matter, my lord.
Just one more short date, your lordship. We can just wait for one more short date, your lordship. If we can get any information from him, then
As requested on behalf of the petitioners, दो है ना? To revision application like list these matters on 5th of April.
Item number 3.
May I please, your lordship? This is the matter your lordship had week before that confirming conviction under section 630 of the Companies Act. The entire impugned judgments are thoroughly perverse because section 630 basic ingredients are not there. Neither I lawfully entered to any company's house, nor the company has filed as per the law. First. Second thing, the FIR was lodged for illegal trespass, and which final report was submitted. But by giving a complete go-by to that original FIR, the complaint has been filed in a different form, adding 630, along with the trespass. But so far the offense on the trespass and everything is concerned, the land magistrate did not take cognizance and only took cognizance of 630. And found the petition here and proceeded with the trial. And he has not considered the ingredients of section 630 of the Act. There is no finding that the petitioner is neither in the FIR nor in the complaint there is allegation against the present petitioner, nor there is any finding that the petitioner is in possession of the house in question. So otherwise the impugned orders are also non-executable because I have been directed to hand over to the house to a person who is not party to the case, to a company who is not a party to the criminal proceeding. So in this matter, the entire proceeding is thoroughly perverse. And as I was pointing out to your lordship, the complainant himself is dead, is not, no one has come, either the company nor his legal or nothing. So in that view of the matter, because the judgment itself is also otherwise not, there is no finding that I was in possession. And the direction is also that to pay a fine in default to go for imprisonment and to hand over the house, which I am not in possession, telling which again imprisonment. So that the order itself is thoroughly perverse without having a finding that I am in possession of the house.
There's a part.
Item number 4.
No representation. 5th.
Item 5.
No representation.
Item number 6.
5th.
Your Lordship, in item number 6, Your Lordship, we have sent intimation to the petitioner, Your Lordship, who is approximately some 80 years old now, Your Lordship.
So what do you want?
So we want to adjourn some more time so that we can get a word back from him, Your Lordship.
Yes, as the question.
Item 7.
No representation.
Item number 8.
8, my lord, I pray for next week on any date, my lord, because my file.
As requested, 5th.
Item 9.
9 also, my lord, I pray for 9.
Item number 10.
No one appears, 5th.
Item 11.
None.
Item number 12.
Yes. Same order.
Item number 13.
Same order.
Item number 14.
Same order.
Item 15.
My lords, I may be pardoned, my lords. 15, I pray for adjournment. My lords, a year-old case. My lords, brief has been transferred to me.
So what do you want?
My lords, I pray for adjournment, one adjournment.
One and as requested on behalf of the petitioner, list this matter on 5th.
Item number 16.
That's it, item number 16, kindly praying for an adjournment.
5th as requested.
Item number 17.
But please, my lord, I'm appearing for the petitioner, my lords. In this case, the noting has come that the police papers and the certified copies, deposition copies have not been filed, my lords. My lords, the only difficulty is my perusing last order 3/4/2023. My lords, the report has come from the district record room civil Cuttack that the records have already been destroyed, my lords. So that is the only difficulties, my lords. And I pray that if one more chance is given, we'll try to collect as much as possible.
As requested.
Deeply appreciated.
Oh, yeah.